Yeah, my lord.
Yes,
I would like to mention one unlisted matter, my lord.
unlisted. This,
Yeah.
what is this about?
Criminal petition, my lord. Only notice may be issued, my lord.
Okay,
My lord. Obliged.
last item.
My lord, I have the same prayer, my lord. Criminal petition, my lord.
Why in the last case? Okay, okay.
Only for this issuance of notice, my lord.
Hmm?
Only for issuance of notice.
Oh.
But Chief, I would like to mention one mail application only to issue the notice.
May I, my lord? My lord, item number 7, my lord. It may,
7.
item number 7.
Hmm.
It may be after puja break, my lord.
You are
After
for?
this vacation.
You are for?
Petitioner.
Petitioner.
I have taken consent from the other side.
Okay, Mr.
T. Kamchi.
T. Kamsi, direct counsel for the petitioner, with the consent of the other side, prays for listing this matter after the puja break. The prayer is allowed. List this matter after the ensuing puja break.
Interim order is there.
Interim order is there.
Yes.
The interim order passed earlier, shall continue till the next date. Okay.
Much obliged.
My lord, may I mention item number 12 for an adjournment?
Item
12.
12.
Yes. This matter may be listed after vacation.
Okay. You are
About the petitioner,
Mr.
M. Khambo.
Land counsel for the petitioner. Prays for adjournment of the case and to be listed after the puja break. The prayer is allowed. List this matter after puja break.
Obliged.
My lord, may I mention item number 32, my lord, supplementary hearing, my lord. I am for the respondent hearing, my lord. And I've taken the consent of the other party also, my lord. My lord, this matter may be listed after puja break.
Mr. M. Kato, this is
Item number 32,
Here appearing here the private respondent.
my lord.
Okay, Mr. M. Kato, direct counsel for the respondent with the consent of the other side. Prays for listing this matter after
Puja break,
the
my lord.
puja break. The prayer is allowed. List this matter after puja break. Okay.
My lordship, there is interim.
There is interim. The interim order passed earlier shall continue till the next date. Okay.
Much lord.
You are also, yeah.
I for a petition.
Okay, Mr.
L1,
L.
BAM.
Bam, direct counsel for the petitioner. So petitioner is also present. Okay.
Deep love.
May I beg your lordship? Your lordship, I would like to mention item number 35.
30.
Criminal appeals. I'm for the appellant hearing, your lordship. Can this matter be fixed on 30th of this month, your lordship, after puja break?
Mr.
Peace hearing, your lordship.
T. Siring, direct counsel for the appellant. After puja,
After puja on 30th, possible, your lordship. 30th of
prays
October.
to adjournment and to be listed this after 4 weeks. The prayer is allowed. List this matter after 4 weeks. Okay.
Can it be a fixed date, your lordship, on 30th?
Have you informed the other side?
Yes, your lordship, I have taken the consent of the Learned PP
Okay.
also.
Then Mr. Siri, direct counsel for the appellant, with the consent of the other side, prays for listing this matter on 30 October.
30.
30. The
Lordship,
prayer
there is an-
allowed. List this matter on 30th.
There is an interim order, your lordship,
Stop.
that may be extended.
Till then, the interim order shall continue. Okay.
Highly obliged, your lordship.
May I please, Lordship. Lordship, I beg to mention item number 10. Item number 10.
10.
Yes. Conducting counsel, Mr. K. Lawler is out of station, Lordship.
You are Mr.
I am for the petition.
You are Mr.
Jitai.
G.
Tai. Yes.
Direct counsel submit that the conducting counsel, Mr. K. Lowland, is out of station and prays for adjournment
Matter may be listed after puja break.
after puja break. Please pray for comma. List this matter after the ensuing puja break. Okay.
Highly obliged.
May I, my lord? I beg to mention item number 31 on behalf of N. Ratan.
On behalf of,
N. Ratan,
okay,
connecting counsel. He is out of the station. So matter may list after 4 weeks.
you are Mr.
P. Harming.
Have you informed the other side?
Yes, my lord.
Okay. Mr.
P. Harming, Punyo Harming.
Make a mention on behalf of Mr. Nino Nerong, Nino Ratan. Nino Ratan. Stating that make a mention stating that the conducting counsel, Mr. Nino Ratan, is out of station and prays for adjournment of the case. So, the learning counsel has also consent of the other side and prays for listing this matter after
4 weeks, my lord.
4 weeks. The prayer is allowed, list this matter after 4 weeks.
Much obliged.
Your Lordship, I'd like to mention item number 27 and 28. For the conducting counsel is out of station.
Well, you are for
For respondent.
respondent.
Yes, Your
Have you informed the petitioner?
Yes, Your Lordship, I.
For appellant.
Okay. When do you want? After? When do you want?
After vacation.
On the prayer, on the joint prayer made by both the learning counsel for the parties, list this matter after puja break. Okay.
Much obliged.
Your Lordship, I would like to mention item number 19.
Yes, what do you want here?
Kindly adjourn the matter for today, as the leading counsel, Mr. Bengya Arun is not unwell. Is unwell.
You are Mr.
Mr. Tamabo, T. Abo.
B. Abu. Submits that the leading counsel, Mr. B. Abu, is out of station and prays for adjournment of the case for the day. The prayer is allowed. List this matter
After 2 weeks, Your Lord.
after 2 weeks. Okay. List this matter after 2 weeks.
My Lordship,
Yes.
Lordship, I would like to mention item number 8, Lordship.
Item 8.
Kindly, Lordship, matter may be fixed on 29 of this month for admission hearing. I have taken the
29?
consent. Yes, Lordship. Item 8, Lordship.
Mr.
L. Bam for the petitioner.
L.
Bam.
Bam, learning counsel for the petitioner. Have we informed the other side
Yes, yes. I have taken the consent.
with the consent of the other side? Prays for listing this matter on 29
29 of this month.
October. The
Lordship,
prayer
there is
allowed-
interim order.
The prayer is allowed. List this matter on 29. Sir. The interim order passed earlier shall continue till then. Okay.
Wait.
Yes. please.
My lord, it appears everybody is in the, since the vacation is from tomorrow.
Vacation.
I also beg to mention 2 matters, 33 and 34, hearing matters, man.
Okay.
After,
So when do you want? After break.
After,
Okay. Mr. D. Pangu, learning counsel for the petitioner,
in 33 petition.
prays for listing this matter after puja break and after entering after puja break. Stop. List this matter after entering puja break. Okay. Item 34 also.
34, my lord, I have not been able to this outside, my lord. I'm not been able to inform them.
You are for the
I am for the
respondent here.
respondent, yes. Yes, what you guys counsel, I don't see them here also. I don't know if any application for online been made or not.
So what do we do? So we wait for some time or what?
We'll wait, my lord. Watch
Wait
it
for some
from-
time.
yes.
Okay. 33 only, huh? Yes.
Lordship, I beg to mention item number 26.
Item
26, Your Lordship.
26.
Yes, Your Lordship, kindly matter may be fixed after puja break.
You are for?
I am appearing on behalf of Titawa for the respondent, petitioner, sorry, petitioner.
Why after puja break?
Uh,
This criminal petition.
This-
You are Miss
Enondik,
Learning counsel for the petitioner. Your name is
sorry, Your Lordship. Yes, for this man.
you're
No,
not
Your Lordship.
not- yeah, okay. submits that the leading counsel, Mr. B. Tava, is out of station and pays for listing this matter. for Puja.
Not out of station,
Hmm?
not out of station,
Okay,
but
where
the
is
matter may be listed after puja break.
After Puja vacation.
Yes, your lordship.
Okay. Okay, Miss so-and-so, huh? Made a mention on behalf of Mr. B. Tava, counsel for the petitioner, who praying for listing this matter after Puja vacation.
There is an interim also,
Prayer is
lordship.
allowed, list this matter. There is the after Puja break, start. The interim order first earlier shall continue till the next stage. Okay.
Much obliged, your lordship.
I may please, Your Honor. And I beg to mention an unlisted bail matter to be taken up today.
Criminal,
Criminal bail matter, Your Honor.
bail. Okay.
Deeply obliged.
May your lordship, I beg to mention item number 36.
36.
Yes, 36.
Yes.
Yes, your lordship, the conducting counsel is unwell today, so matter may be adjourned.
Leading counsel is?
Unwell.
Okay. Miss,
Eighth alum.
you,
Eighth alum.
8 alum. Submit, counsel, submit that the leading counsel is unwell and pray for adjournment of the matter. The prayer is allowed. List this matter after
Vacation.
2 weeks. Okay.
My lordship.
Yes.
Lordship, I would like to mention item number 24, lordship.
Item
24.
24.
This is an order column, lordship. I have taken the concern from the other side, lordship.
Okay. You are
For the petitioner, lordship.
petitioner.
L1, lordship.
Okay. Mr. L. Baum, land counsel for the petitioner, with the consent of the other side, prays for listing this matter after
3 weeks, lordship. 3 weeks, lordship.
after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
Lordship, there is interim also, lordship.
Interim. The interim order passed earlier shall continue till the next stage. Okay.
Okay.
My lordship.
Yeah.
Lordship, leading counsel, Mr. Titi is engaged in court number 1.
Time.
Obliged.
May I please, Your Lordship?
Yes.
I found 3 citations in my paper. Here,
What it says,
this is the regarding the criminal petition.
what it says.
It says that High Court has a power to was the non.
Yeah, that is true. That is true. But here is the case where
Yes,
the
This is
department is involved.
involved of the PDP acts.
Yes.
And here citation also, in 3 citation
Hmm.
where involved all the prevention of property damage act also involved. And
Okay.
where it was, yes. I will page matter number 1 and related paragraph. I just highlight a small one.
Yeah.
From paragraph 1 itself, it is more serious than my case because case was registered under section 3 and 4 of the Prevention of Damages Act. And relevant para.
Here is the case. Admittedly, you also say that damage the
Yes.
property.
Yes. Kindly see the paragraph 7, 8, 9 and 10. These are the relevant. This all are the based on the settled law which was passed by our address court. Based on the settled law, this case was. Then another also involved in the section 3 of the Prevention of Corruption Act. Here also, second one also involved the section 3 of the PDP Act.
You obtain instruction. And then if they want, they can file.
Your Lordship, Your Lordship, the one more issue is there, Your Lordship. It is well settled that the matter can be this can be quashed
Yes.
if it's connected to matrimonial dispute, family dispute. And second and lastly, the main factor is when the entire party has settled the matter among themselves. But here, some of the victims are not enter into an agreement. Who has been assaulted by the accused, Your Lordship. Your Lordship may kindly come to the this FIR, Your Lordship.
Have you made party to the all?
Yes, all of the petitioner before this honorable court, Lord. All the victims, including, and
So
if you go,
they are petitioner, but then whether they are party to the agreement.
kindly see in my petition 35, page 35.
Hmm?
Page 35. Just after FIR.
Yes.
Here is the very initial settlement, that is, which included this petitioner number 5 and 6 that as per this undertaking, the accused petitioner comply entire terms and conditions. So they have no any grievances. Even here, they have performed as per their wishes that puja called Rogum. Appears seems to be very serious, but no injury is such a only bruise. I have annexed in the page
Just see whether they have signed affidavit.
46. Kindly see 46, page 46.
What is 46?
46 of the petition.
What is this?
This is just
It's injury, Your Lordship.
just injury report that
Your
is
Lordship, we are not on that, Your Lordship. The settlement, so far as settlement is concerned, because Your Lordship, law is very clear. It says when the parties has entirely settled the matter entirely among themselves. Here, Your Lordship, they have no doubt, they have made them as a petitioner here. But so far as the settlement deed is concerned, they were not the party in the compromise deed, Your Lordship. And Your Lordship, PDPP Act is concerned. It's a public property, no doubt, Your Lordship. And the Supreme Court clearly says it shouldn't be against the public property. It shouldn't be against the public at large. The ambulance is not belong to an individual. It's against, it's for the public, Your Lordship.
That is obtain instruction is required file affidavit.
my brother has not gone through the recent judgment on where PDPX and other.
No, Your Lordship, even the STSC Act can be quashed, no doubt, Your Lordship. I know to that extent that even the STSC, very serious one, can be quashed. But considering the fact and circumstances, Your Lordship. Now, whether this person can enter on behalf of the government, Your Lordship.
That is why.
That is one of the issue. Whether, no doubt, PDPP can be quashed, no doubt. But whether he is the rightful person who can enter on behalf of the government, whether government authorized him to enter on behalf of the government to compromise this.
That is why you obtain instruction if necessary file objection.
Yes, Your Lordship.
For Mr. M. Bhatt, and counsel for petition. Para. This is an application filed under section 482 of the Code of Criminal Procedure, 1973, paying for quashing and setting aside the criminal proceeding. Of GR case number 12, 2023, under section 323 of 354, 447, 34 IPC, and section 3 within bracket 2 within bracket E of the Prevention of Damage of Public Property Act 1984, arising out of Panging Police PS case number 01 2018 under section 341, 323, 354, 34 IPC, read with section same, section 3 of PDPP Act 1984, which is pending before the Court of the Judicial Magistrate First Class Pangin, P-A-N-G-I-N. Start. So the case has been submitted into charge sheet.
Yes, already now fixed for examination of PWs. It's no
Charles Prem also.
For the scan copy of the
PCR.
PCR, issue notice, returnable by 3 weeks.
4 weeks, Your Lordship.
4 weeks or 4 weeks stuff since Mr. P8. So it landed additional PP accepted notice appeared and accepted notice on behalf of the respondent, state respondent. No formal notice need issued to the state respondent staff.
interim
Please.
proceeding maybe. Interim proceeding maybe stay.
List this matter after 4 weeks. Whether the evidence has already been recorded in the trial court.
It's for
No.
PW now, Your
No,
Lordship.
PW for it. Just to start.
Trial just commenced, Your Lordship.
This month 17 is fixed for examination of witnesses. That may be stayed off.
In fact, Your Lordship, if the evidence is adduced, that will be better. That will be better for him.
Yes.
Actually, Your
That will
Lordship.
be your advantage. only.
Yes, Your Lordship.
Because the informant is with you.
Yes, because
If the informant doctor gives in your favor, the case is gone.
then actually issuing the notice will not mean that
No,
because see,
no.
one thing,
The
Well,
case,
we
this,
are-
this case will be disposed of on merit after perusal of the records only. Scan copy of the records. But then that will continue
they-
proceed.
our-
If it goes against you,
no, our claim is only on based on compromise, not based on merit.
that is why I'm saying the party who has compromised, the victim is with you now. What
Even
he,
then,
what the
Lordship-
doctor, the informant will depose will be in your favor, it appears.
Even
in
then,
view of the agreement.
Lordship, proceeding will be taken place here and again proceeding will be here. That will not.
No problem at all, no problem at all.
That
That is for your advantage. That will be, you will be benefited with that. In case it goes against you. Then, and then with the records, if the evidence also comes that nothing, there is nothing.
That will be not
The
there.
informant is not make, informant has not made any allegation against you, then automatically it will go in your favor only.
Sure.
Anyway, in the
Fair.
meantime, the proceeding of the further proceeding of the GR case number 12, 2023, under section 323, 354, 447, 34 IPC, read with section 3 within bracket 2 within bracket E PDPP Act shall remain stating the next returnable date. Okay.
Obliged.
Yes, deeply obliged.
Otherwise, there will be parallel trial will be going on.
Lordship. Lordship, this criminal petition filed under section 528 PNS Act 2023 for quashing and setting aside of GR case number 1167/21 in ITA WPS case number 186/21 under section 448, 435, 323, 34 IPC. And for quashing and setting aside of common order dated 19/7/2024 in ITA WPS case number 186/21, wherein charge was framed against petitioner 1, 2, 3, and 4 by Honorable Chief Court of Chief Judicial Magistrate, Capital Complex, UP. Lordship, this is the case, the dispute between petitioner, joint petitioner number 1, 2, 3, 4, 5, and 6, for the marital dispute. So, Lordship, they have entered into a settlement. The settlement copy is in page number 100. The page number 100. The settlement was entered on 20th of September 2024 at Lungte Tapu village under Lepuran Circle, Sagali district of Arunachal Pradesh, among the joint petitioner, 6 joint petitioner. Lordship. So, since the
trial of the case began.
Lordship.
Trial of the case.
Trial for debt, third frame under section stages of evidence stage. Charges framed against petitioner number 1, 2, 3, and 4. In the common order, Lordship, common order page 24. The
Charge framed.
charge frame.
Okay.
A common order is passed.
Next date is fixed for evidence.
Yes, sir.
What is this High Court order?
Common order 19 passed by the.
What is this High Court?
Bail order.
This is what bail court order.
Bail order. Earlier, bail order passed by this honorable court.
Okay, bail order.
Yes. Sir.
Common order, Lordship, page 24. Passed by Chief Judicial Magistrate UP, framing charge against petitioner number 1, 2, 3, and 4.
Okay.
Order dated 19/7/24. A common order is
What is
passed.
your prayer?
My prayer is for quashing and setting aside of GR case number 116/7/21 in ITA WPS case number 186/21 under section charge framed under section 448, 435, 323, and 34 IPC. Only 435 is the Lordship non-compatible, and rest are compatible. So we tried there in the court below. So no option. So approach joint petition approach this court for quashing and setting aside of the GR case number 1167/21 ITA WPS.
Yes.
Yes, Lordship, here in this case, 15.1 of the State of Madhya Pradesh versus Lakshmi Narayan would apply, Your Lordship, because the offense, it's purely a matrimonial dispute. I've gone through the Your Lordship record and the agreement as well, Your Lordship. The petition, the party number 3, the husband has a extramarital affair with a victim, Your Lordship. And because of that, there is a scuffle between the parties. And for that, Your Lordship, ultimately, both the parties has filed a FIR. So now, in agreement, it has been clearly reflected, Your Lordship, that the accused will marry the victim, Your Lordship, as a wife, and the first wife will separate it with the husband, Your Lordship.
Okay, that is the agreement.
This is the agreement, Your Lordship. It's a purely a matrimonial dispute. Your Lordship. So, Your Lordship, here, Your Lordship can invoke the power under 482 or the corresponding section 528 of the BNSS, Your Lordship. Your Lordship will fall under 15.1, Your Lordship, of the State of Madhya Pradesh versus Lakshmi Narayan, Your Lordship. At this stage, Your Lordship, what my humble submission would be, Para, Your Lordship, 15.
Yes.
Yes, Your Lordship. Considering the law on the point and the other decision of this court on the point referred to herein above, it is observed and held under 15.1 that the power conferred under Section 482 of the Code to quash the criminal proceeding for non-compoundable offence under Section 320 of the Code can be exercised having overwhelmingly and predominantly the civil character, particularly those arising out of commercial transaction or arising out of matrimonial relation or family dispute, and when the parties have resolved the entire dispute among themselves. Here, Your Lordship, this will come. Because, Your Lordship, in the dispute, matrimonial dispute, not only 498 will come, definitely there will some injuries also, Your Lordship.
Yes. Yes.
That has to be construed in that manner, Your Lordship. So this 15.1 will apply in this case, Your Lordship.
So no need to.
Here in Your Lordship, in this case of the Lakshmi Narayan, the Honorable Supreme Court has given stress that even if the offense which are considered the heinous one is incorporated, the High Court may not stop, Your Lordship. The High Court has to see whether the section is incorporated just for the namesake. So for that, Your Lordship, the High Court required to peruse the record, Your Lordship. Whether it is just for the namesake, whether the section is attracted or not. Even if 307 is inserted in certain cases, if court find that no case is made out, then even in such case, the court can exercise its power, Your Lordship.
So then, now,
Your Lordship, even without calling the record, this can be quashed, but I leave it to Your Lordship, my Lord.
So, Lordship, my humble submission, issue notice to the respondent, and in the meantime, pray for interim to stay the order, that is common order.
there are two cases.
Yes, let's club together and common in the learned court below has so charge frame in one section, because same incident
Same
and
party.
same complainant, two police station.
Different police station.
Yes. So if the case two case was clubbed together. The common order was passed.
Even in order to pass the order,
So, Lordship,
probably record need to be.
Yes, Your Lordship may call for the record, and in the meantime, the proceeding may be stayed, Your Lordship.
Also settled, already they are married, living peacefully.
Okay. Or what? Have you annexed all the records?
Charge sheet order,
Charge sheet,
common order is annexed,
Okay.
and charge sheet is annexed, and settlement is annexed,
FIR also annexed, Your Lordship.
FIR annexed, both PS.
Is that, I think that should be enough.
That is enough, Your Lordship.
Mm.
That is
Then
why
why-
I'm submitting.
I'll pass order.
Yes,
After
Your Lordship
they
may
inherit
pass the
court-
final order, Your Lordship. No need to call for the record. Pass the final
Yes.
order, Your Lordship.
So take effect of the case.
The fact is that
Okay, Mr. Arregam.
Arnabam was-
Arnabam, Regam Nabam. Land Council for the petition. I've also heard Mr. Ekdeha, additional PP. Start. This is a petition filed under section 528 of the Bharatiya Nagarik Suraksha Samhita within bracket BNS of 2023 for quashing and setting aside of GR case number 1167/21 arising out of Beta WPS case number 186/2021 under section 448 stroke 435 stroke 323 stroke 34 IPC. What is the other?
Order is the PS case number
And
71/21.
where it is?
It is reflected in page number 6. What's it? Page number 6.
Not in the course title.
Or in.
No, your prayer is only to pass one.
Yes, that's common order. In this case,
After
yes.
clubbing, it has been named as GR case number 1167.
Yes, and in ITA PS, ITA WPS.
After clubbing.
No, no, that is in ITA WPS.
In the order itself,
And what about the no PS?
the WPS case number, that
71 of 2000, your lordship will find in the synopsis. They have written this in the synopsis.
Not in the full title.
synopsis,
Synopsis.
yes,
Your Lordship.
71. In the second para lordship, 71/21 under section,
And DMK, PS case number 71. Section 447, 448, 323, 435, 34, IPC. Just a minute, where is the magistrate or the way it is together?
page number lordship 24. Annexure B series.
Where it is mentioned, both the PS case and then club together.
Page 25. Therefore, invoking the provision under section 220 CRPC, trial of instant WPS case number 186/21 and Duybook PS case 21 arising out of same offenses, all shall be tried together here
Where?
onwards.
Para?
Para number,
First para after 1, 2, 3,
Line.
4, 5, 6, 7, 8, 9, 10. 11 line, your
11
lordship. It's in bold, your lordship, under section 220, bold.
Okay.
Therefore,
Okay. WPS case number ND, okay. Okay. Then the para, the petitioner number 1, Navam Nitin. Petitioner number 2, Techi Tajun. Petitioner number 3, Navam Vision. And the petitioner number 4, Navam Merch, MERC. H. R. The accused. And the petitioner number 5, Miss Target Chokru. Petitioner number 6, Sri Techi Hita, HITA, are the informant in the, sorry, just petitioner number 5, Miss Target Chokru is the informant in WPS case number 186/21. And the petitioner number 6, Sri Techi Hita, is the informant in DMK PS case number 71/21. So, the case of the petitioner is that where is the FIR? FIR.
page number 20 lordship. This is the FIR file before demo PS, that is 71/21. And
Page?
page
No,
20.
Page, what
Uh,
did you say? Page?
and
No, first FIR.
first FIR is page 22.
Women PS is
Common PS, page 22, that is page 22 lordship.
22. That on When it was?
On 3rd,
Oh,
incident happened on 3rd and FIR filed on 4th.
okay, on 4/12/2021. The petitioner number 5 lodged a written FIR before the OC, Women PS, Itanagar. Against the accused petitioner number 1, 2, 3, and 4, alleging that the accused came with a lethal weapon, and repeatedly punches and kicked her body and also snatched away. They illegally entered his premises and with lethal weapons and started assaulting her with punches and kicks, and also beaten with the iron rods and sticks. The accused also snatched away the personal belongings along with the case amount of rupees 50,000. Basing on the above written FIR, the police has registered the above women PS case number 186. Women PS case is 186. 186. Women PS case number 186/21 under section 448, 435, 323, 34 IPC. And where is the other FIR?
Under is page 20, Lordship. Page 20. Page 20, another FIR. Second FIR before Dubuk page 71 is page 20. Page 20.
Okay.
Subject past information report.
Okay.
It is to bring your kind notice that on 3rd December 2021, around so and so, at MC village.
Petitioner is that on the same day, that is on 4th, on 4/12/2021.
Didn't happen on 3rd as per FIR and on 4th. FIR on 4th.
4/12/2021.
No, sir.
Okay. The petitioner number 6 also lodged a written FIR against the accused petitioner number 1, 2, 3, 4
Before doing PS.
Before the officer in charge police station, Doimok, against the petitioner. Petitioner number 1, 2, 3, 4. Accused petitioner number 1, 2, 3, 4. Inter alia alleging therein that the accused person along with the other along with a group of people came and group of people around 30 in numbers attacked him from all over, causing him injuries on his body. Came along with the It came with the lethal weapons, with an intention to and attack him with causing attack him, causing him injury all over his body, resulting and as a result, he was brought to just a minute. Not only that, the accused petitioner number 1234 also burnt down the belongings outside the house, including the belongings of the petitioner number 6 outside the house, including the educational certificate, and also snatched away the sum of rupees 1,60,000. Due to the said attack, the accused, sorry, the petitioner number 6 had to be admitted in Tomoriva Institute of Health and Medical Science, Nahalagarh, staff. Based on the above FIR, the police has registered the above mentioned NDPS case number 7121 under section 447, 448, 325, 435, 395 IPC. The above two police station cases were investigated into, and on completion of the investigation, the IO of the case has submitted a separate charge sheet before the Chief Judicial Magistrate, before the court of the Chief Judicial Magistrate, UPR. So when this on receipt of the charge sheet, where is it? Where is the order?
Order,
Magistrate order.
Magistrate 24 pages, Lordship, page 24. 24, Lordship. Common order. Charge frame under WPS 186.
And since both the above police PS cases arising out of the same offense, the learned magistrate, by invoking provision under section 220 CRPC, CRPC had the learned Chief Judicial Magistrate by an order dated 19/7/2024 has invoked the provision under section 220 CRPC. And directed for trial of both the WPC case number 186/21 and DMKPS case number 7121 together Stop. And stop, and on the same day, a charge was framed against all the four accused applicant number 1, 2, 3, and 4 for offense under section 448, 435, 323, 34 IPC. Start. The learning counsel for the petitioner submits that the petitioner number 6, in the instant case, the petitioner number 6 is a husband of petitioner number.
Now petition number 5. 5 and 6 they married now. And
No.
the main, yeah, petitioner 1.
Okay, just a minute, then, okay. 6 is the married, is a married man. He indulged in extramarital affairs with petitioner number 5. And being, so who is the wife earlier? Prior to 5?
Wife,
Petitioner number, which one is?
wife is not here in the joint petitioner because
Wife is not in.
not in the
here.
petitioner. Only the complainant and the accused. And wife has entered into, the main wife has entered into the settlement,
Settlement.
Settlement.
But not in the case.
not in the case. Because her case, he lost one.
She was not implicated as accused.
No,
Okay,
no.
Mary,
Settlement.
so who are these accused then?
Accused 1, 2, 3, and 4 petitioner.
And who are these?
They are the brother of the main, the wife.
Okay, okay, okay,
Petitioner 6 wives.
okay.
6
The-
is a husband.
The accused petitioner number 1, 2, 3, 4 being a brother of the wife of the
Petitioner
petitioner,
6.
petitioner number 6 on 12, on 4/12/2023 with a view to save the life, save the marital life of the accused. Life of the petitioner number 6 and his wife has assaulted the petitioner number 6, due to which petition number 5 and 6, due to which the police has registered the above 2 PS cases. So, the learning counsel for the petitioner further submits that, however, during the pendency of during the investigation, only this agreement entered. When the agreement entered?
When this already charged with crime,
Okay, when
charge
after
crime.
charge frame.
That settlement
Where is the
arrived
agreement? Where is the settlement?
on 20 September.
Page.
Page 100. Also. Settlement is page 100. And charge frame is in common order itself.
Submits that during the pendency, the informants, both the informants and the accused, the informant petition number 5 and 6, and the accused petition number 1, 2, 3, and 4 has mutually settled the matter and executed a mutual settlement on 29/2024. As per the said mutual settlement,
Settlement, Lordship, para 1 and para 6. Party number 1 and 3 has agreed upon to withdraw the FIR filed against party number 4, 5, and 6 and approach the appropriate court for compounding and quashing. And para 6 that the parties.
The relevant portion of the mutual settlement is
Para 1 and 6, Lordship.
1 and
6. 1 and 6, para 1 and 6, that's
has agreed
in the
to
settlement.
FIR file against one, so. No, I think 1, 2, 3, 4, 5, 6 are important.
Yeah.
Reproduce here in below. 1, page 103, 1, 2, 3, 4, 5, and 6. Stop. Okay, these are your submission.
That's it.
Okay.
And
And your submission, this will be recorded.
Yes, Your Lordship.
So rest will be dictated inside.
Yes, Your Lordship. Deeply obliged.
high level is.
Yes. Yes, next. Yes.
My friend is very lucky today.
Ah.
This is a 2013 page petition, with annexures. He just got the file. But I'm not pressing the interim order today because the order was passed way back in January. But I will kindly come to page 23.
Okay.
This is the orders we are putting to challenge on page 23.
2, 3.
On the ground that it is totally a civil dispute. Because there were monetary transactions. What I'm, my lord, submitting, my lord.
Okay.
My lord may call for the scan copy of the GR case, my lord, from the CDM. And matter be fixed on 28th of this month.
Okay.
And my lord, an endeavor.
So this
of that-
appears to be civil case.
Yes, to my understanding, my lord.
Yes.
But there is some delay, my lord, January, my lord, so I am not pressing today.
406 criminal breach of trust and 420.
Yes, that is right. So, okay, we can call for the record.
We
Let us
can
see-
copy, my
let
lord,
us see.
and steps upon the respondent number 2 through the Pacific police station.
Okay. Mr. Pang, Land Council for the petition. This is an application filed under section 482 of the Code of Criminal Procedure, 1973, praying for quashing and setting aside the FIR number. The quashing of FIR.
Yes. FIR, all
Already
everything.
case charge sheeted.
Charge sheet as well as the order
Charge sheet.
by which charge was framed.
TCR, trial court record.
Okay.
Scan copy of TCR, maybe call for.
Where is the GR case?
GR is 5, serial number 5, my lord. Serial number 5 at page 23. GR number 07/2021 in Pasigat PS case number 7 of 2020.
Page 23.
Page 23. Otherwise, your lordship will find at page 211.
Okay, GR case number. Wait. GR case, GR number 07/2021. Okay, arising out of
Pasigat PS case number
Pasigat PS case number
07/2021.
07/20, no, that is GR. That is also 07.
Yes,
Okay,
my lord,
07/2021.
page 211, my lord.
Okay, both are 07/21.
Yeah, appears so.
Okay, under section 420 only.
Yes, ultimately, charge was framed under 420.
Okay, 420 IPC. No, arising out of PS case was, police has registered under
Yes,
what section?
406 and
Okay,
4.
406 stroke 420 of the IPC. IPC, stop. IPC. And also this order 0103/2024 is framing
Framing of charge.
framing of charge against accused.
Yes.
This also.
Yes.
So since the GR itself is challenged, this required to be noted. GR case itself is challenged.
Yes, yes, it is there, my lord, but the abandoned caution, my lord,
And
we have
the
challenged.
order, and the order dated 01/03/2024 passed in the above GR case. Passed in the above GR case number 07/2021 by the Court of Chief Judicial Magistrate, Pasigat. Okay. Okay, just a minute. Then call for the trial court report, scanned copy of the trial court report. Yes. Issue notice. Since Mr. G. Tadam, Lane additional PP has accepted notice on behalf of the said respondent. No formal notice need be issued to the said respondent number one. The petitioner shall take steps upon the respondent number two.
Yes. And the steps upon the respondent number 2 be taken through the Pasigat police station, ma'am. That is to go through the registry.
To through Pasigat PS.
Yes.
Through the OCPS Pasigat.
Yes.
Not by a registered post.
My lord, this is under the CRPC, but the registry,
Right.
we will
Right,
submit a
right,
copy
right,
to the
right,
registry, my lord.
okay. So through. List this matter, as prayed for, list this matter on
28th of October.
28. Then will it reach?
Should, my lord. Scan copy.
Yes, sir.
Okay, 28.
It can be.
My lord, may make an observation in the event records are received and endeavor for disposal, otherwise interim prayer may be possible.
Okay. Then we'll say interim prayer will be considered on that day.
Yes, exactly.
The interim prayer shall be considered. Now, on which date the interim prayer shall be considered? Okay.
Highly applaud.
Because arguing for interim matter in this case would almost amount to arguing the whole matter. I will have to place everything.
Right. It is private basic it appears as a civil matter.
Yes,
It appears so. There's some delay, so that's why I did not press for the interim order. That was framed back, way back on January.
Okay.
My apologies, Milord,
Yes,
for passing the matter for
please.
time being. Milord, the case in nutshell is like this, Milord. Before I burden my lord with the lectures. Milord, there is a clan called Chaku clan in Panyasan circle of Kurunkume districts. They inherited a customary land, Milord, from generations to generations. And then the private respondents are also part of the same clan, but of the different father, Milord, in terms of genealogy tree. Then most of the family members of the petitioners, they resides outside the town. And then they requested that we should be allowed to look after, accordingly we allowed. Till 2023, my lord, the private respondents, they created the dispute. That no, you have allowed us to cultivate. Then we dispute this, now we will not return the land to them. Now, in that regard, my lord, what did happen? First, there was a Kaba proceedings. The village authority having a
Who lodged complaint?
by us.
Okay.
So petitioners. Then what did happen?
That village authority was having
Yes.
jurisdiction.
The
That is
village
within the
authority,
village,
yes,
within the village.
within the village.
Okay.
In terms of section 2B or A
That is still
definitions
pending,
of the.
not yet settled.
No, it's still pending, Milord. It's still
Okay.
pending. The first Kaba was held
Ah.
on 17/4/2023.
Yes.
That Malad will see this. I'll demonstrate from here. Photograph itself is there.
There is no order, I think.
No,
Was there any order?
No,
order?
no, that first village authority decision is pending disposal by the village authority.
But the complaint was lodged by you, whether you have you annexed the
Yes, then
complaint?
what had happened, no, what had happened was the president of President all Panyasan, the Damin, I think, circle.
No, the first kaba
Yes.
in the village,
Yes, ma'am.
whether have you annexed the copy of the complaint lodged by you, if there is no order?
No, 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 ma'am, no complaint, because it was on the verbal.
Okay, verbal complaint.
Verbal complaint, and we made it, Milord.
Okay.
Then, Milord, to resolve this dispute,
Hmm.
the first kaba was held on 17/4/2023. Then the kaba remained indecisive because then we inquired what is the reason for indecisiveness of the kaba in disputing, in adjudicating the case. Then we find out the president of the all Panyasan, Damin Ansarli, Gamura Welfare Association president, is the relative of one of the respondent, because he is
Who
younger.
is the relative? Who
Yes.
is the relative?
That respondent number, respondent number 1,
Relative of?
the president of the
Okay.
president of the All Damin Panyasan Gambura Welfare
Okay,
Association.
who has started the
Yes.
mail order?
Now, the short question involved pendency of the
No,
decision.
just a minute. Even as per the civil court act, whether the president of the association has any power and authority?
No, my lord, they don't have. Because the first thing, my lord, will clarify, once the original the village authority having original jurisdiction,
Yes.
the matter is in session of them. They are yet to pronounce the verdict, my lord.
Right.
In that case, the appellate authority cannot exercise so moto power.
Now, whether this is appellate authority?
Yes.
The president is appellate
Yes,
authority.
that
How?
interpolates. That
Under-
there is
under-
section 24.
24.
That AFR, huh? Yes.
AFR, do we have
Well, that new volume.
AFR?
Milord can read this.
Okay. New.
Yeah, new volume 1. Any party agreed by the decision of the village authority, Milord.
No, new means this is after.
There is a new volume, Milord, fresh volume. No, fresh volume, first volume.
After the amendment.
After the amendment.
Okay.
The page section 24, Milord will get.
No. So that body, appellate authority, the Inter-Village Territorial Customary Court.
Okay.
What I'm asking is, my question is, this is the association.
This is persona non grata, but then persona non grata organization in terms of our AFR and in terms of this. And there is one judgment, Milord, that Abu Maj family and all those other judgments. Then few judgments which we have dealt somewhere in 2011-12.
No.
In that judgment,
Whether the appellate authority can be formed in the form of an association.
no.
That is why I'm asking.
That's why, Milord, there's interference. If that, suppose, if that gentleman, because that is a court in terms of 2A, we did not make him the party who has passed this interim mail order, Milord. Because court cannot be arrayed as a party.
Yes, function as a judge.
So therefore, Milord, there is a catena of judgment by our High Court itself, clarifying that Gambura Welfare Association are a persona non grata under the AFR as well as the AP Civil Code. Now, in terms of AP Civil Code, Milord,
because what I'm saying
correctly
is Gambura Association can be headed by the simple Gambura.
Correct, not required.
But then the authority, village authority, headed by the Gambura, and normally it has to be headed by the head GB.
Head GB. Now, what had happened is, Milord, this political infusion has taken place. Anyone can become the president of
That is
a
why I'm saying.
Gangura Welfare Association.
Hmm.
And that Gangura Welfare Association, my lord, becomes the appellate forum in Nisibel, my lord.
Okay.
And it's like that.
Okay.
So therefore, my lord, in terms of that, where is that section? Section 2, huh? No, section 2. But that's section 2 of, I read out for convenience of my lord. No, AP Civil Code, my lord, I read out the
Okay.
definition clause, my lord. B, my lord, 2B. Civil court means a court of district judge or district judge, a court of and additional district judge, a court of civil judge, senior division, a court of civil judge, junior division, or as customary court, including village authorities, by whatever name called under the Assam Frontier Administration of Justice Regulation 1945. So whatever the name it may call.
So their association is not coming still.
The association is not there. Therefore, my lord, I said it is a persona non grata under law, both the laws, my lord. Say, normally we describe some element as a non-state actor. Suppose something, if some terrorist activities have occurred and they are interfering with the internal sovereign affairs of the sovereign country, then we call them as a non-state actors. Or per se in the governance, my lord, what we call is that, see, it is a cabinet who decides. You are not party to the cabinet. Therefore, you are persona non grata or non-state actor. You cannot dictate the elected.
But that this need to be decided in the peers. Because
Yes.
association cannot be the authority.
My lord has to lay down the law
Association
on the question that whether the Gangura Association, my lord, Gangura Association has the power. Can function as an appellate authority.
Association can be for
Has
village,
been not mandated by the law.
village wise,
Yes.
and then the entire village
Yes.
association. So suppose
Then what happens is, my lord, that in the civil code, my lord, there's letter amendment in 2023. Inter-village court has been recognized. So suppose the first village authority is section 24. That's what we read. Well, first village authority, suppose we take example from Zero law. Suppose the Tajang village. Tajang village, there will be a few Ganguras. And if any dispute has arisen, whether criminal or the civil case, then it will be resolved. The head Gangura will be the presiding judge of that village. Then if the Tajang, then another village, Hong, say, like another in the Hong, the another village authority is there. And then what happens on top of that, if these two villages, the dispute is there, then there can be an appellate authority.
Yes.
So comprising of the two villages, they will select the umpire.
Yes.
Then, you know, that thing is there.
That is there. So, but then where is the role of the association?
Role of the association. Therefore, they are persona non grata. Therefore, you know, can we state this? We will come back because we do not have the power. The order made in inception has no force of law.
Issue notice.
Issue notice and stay this.
Mr. Titi Dara, Land Council for the petition. Start. This is an application filed under Article 227 of the Constitution of India for crossing and setting aside the impugn mail order stroke within bracket notice dated 9/9/2024 issued by the President, Ol Damin Paniasang, EANIASANG, Gangura Welfare Association, whereby the president of the association has fixed
on 10/10
on
10/10/2024.
10/10/2024 at the admin office. It is submitted. That the petitioner is how many numbers? Petitioners and the respondents. It is submitted that there was a then dispute
Correct.
between the petitioners and the respondents.
My lord,
Complaint was lodged before. GB of which village?
Marianga Ringte 1.
Before-
Maringa, yes.
Before the Marianga,
Maringa.
MARIA,
Maringa.
GHA village.
Authority.
GB of the Marianga village.
Correct.
Okay, GB of the Marianga village. And the said case is still pending before the GB of the Marianga village authority. Before the GB of the Marianga village. Okay, the village level of okay, Marianga village. Still pending before the Marianga village authority. Okay. However, in the meantime, the president, by the impute orders within bracket notice, the president of all Damin Panyasang Gaon Bura Welfare Association has issued initial the president of all Damin Panyasang Gaon Bura Welfare Association has issued the impugned mail order within bracket notice dated 9/9/2024, scheduling the mail for 10/10/2024 at Damin without any authority. It is further submitted the said mail order notice has been issued under the guise of appellate jurisdiction. Okay, here it will become appellate jurisdiction without any authority, and in violation of the Assam Frontier within bracket Administration of Justice bracket close Regulation Act 1945 and the Arunachal Pradesh Civil Code of 2021. Stop. Record need not be called for. I think there is no record.
A record may not be
Issue notice returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondents. It's by a registered post with AD as well as by a usual process within a week from today. Within 7 days from today. Stop. List this matter after 4 weeks. Stop. Having regards to the contention made and the submission made by the land council for the petition, in the interim, it is provided that the proceeding of the mail. Is the proceeding or what the or notice is to be?
Notice dated 9/9.
Okay, the notice, the mail order stock, within bracket, notice dated 9/9/2024, issued by the President All Damin Paniasang Gaon Bura Welfare Association by fixing a mail on 10/10/2024 at Damin cell remain state till the returnable date, will say? Okay.
Much of it.
Okay.
May I please, Lordship?
Yeah.
Lordship, this is a quashing petition jointly filed by the accused person and the complainant victim for quashing of the FIR and charge sheet in connection with Naharlagan PS case number 103/2022. Lordship, the present case has been filed into charge sheet, but as of now, the trial of the case has not been commenced. So during the pendency of the trial, the accused person, their petitioner number 1 to 4, and the victim cum complainant is petitioner number 5. They have mutually undertaken and they have settled down the matter and they have jointly filed this petition, and as per their settlement agreement dated 20/12/2022. Lordship, the petitioner number 2 to 5, they have authorized the petitioner number 1 to file this present quashing petition. May I read the FIR? The allegation is regarding cheating 420.
Affidavit, who filed this?
Petitioner number 1, Mirajul Islam.
Where is the authorization?
Lordship,
Authorization?
authorization is at page number
37.
37.
Okay. Yes.
May I read the FIR?
So this is like a child play.
Lordship.
It's like a child play.
Lordship.
Exactly, Your Honor. Here offenses under 419 and 420. But here also involve impersonations. He represented as a manager of the RBI, Reserve Bank of India. Impersonation, this is a case, serious case. How I can
No, see the informant.
No. FIR.
He says that
No.
Prime Minister, he is going to believe that also. It appears.
So tell maybe continue. Go on. And maybe this was by trial court.
Lordship, the informant herself is before this honorable court. That they want to
Herself is before this court.
Yes.
Why she has come? Why she has come?
She want to compromise the case. She want to withdraw the case. Lordship. That's why they have come for filing joint petition.
What we can issue notice?
Yes.
Yes.
Okay. This is funny actually.
Lordship.
Really funny. And then I think there are some other cases also related or this kind of
maybe
cases.
Lordship.
And then the people should learn.
Yes.
You may read the FIR.
On 18/7/2022, along with one so-and-so and her niece went to Lakhimpur to meet one person, namely so-and-so, known as so-and-so, for selling ginger. We met the person who introduced himself as so-and-so and his partner so-and-so at a place few kilometers away from Lakhimpur. while taking about ginger, sorry, yes, while talking about ginger, so and so showed us a machine and told us that it is a machine that he got from RBI, as he is the manager of RBI. The machine is used to make money by RBI, and he has to return the machine back to RBI in few days. He took rupees 5,000 from me to show how the machine works, and instead it is the machine inserted it in the machine, and rupees 20,000 came out from the machine. Then he distributed the money amongst us and asked us to deposit in the bank to check its veracity. We came back to Naharlagan and did as we told. The entire 20,000 was accepted in the bank. After that, they had my trust and told me that if I give them rupees 20 lakhs of rupees, then they will make 80 lakhs from it and give me 65 lakhs from it as kept 15, it should be 15 lakhs for themselves as commission. I trusted them and managed to collect rupees 20 lakhs by asking the money from my relative on pretext of some urgent work. Accordingly, on 25/7/2022, the said guy so and so and so and so came to F sector Naharlagan at my residence and took away 20 lakhs from me. Since then, they have disappeared.
See, this is unnecessary.
Yes. In fact, like victim is very foolish person. In believing in all those.
Matter already charged.
And then see the
Already
capacity.
charged.
With this mentality, she could manage 20 lakhs.
Yes. Innocent and.
So, okay, Mr. Ketu Tava, Dana counsel for the petitioner. Whether there was no any seizure from the accused, it's only machine, the machine which they are talking about, that was not seized by the police during investigation. You said a charge is filed. Is there any seizure memo?
Seizure memo is there, but
so that machine?
No, machine has not been seized.
Okay.
Not been seized.
Because then again he will be punishable by the police again.
Yes.
The police again may also file a FIR against the accused.
Yes, Lord.
This is an application. Just a minute. This is a joint application filed by the petitioners under section 528 of the BNS 2023, praying for quashing and setting aside of the. You said that charge sheet already filed. GR case, where have you mentioned the GR case?
Your Honor, I have not mentioned GR case, Your Honor. It's because the court has not issued process till date.
Not yet issued?
No, not yet issued. Notice has not been issued.
Then
trial has not been commenced.
Now the FIR, the quashing of FIR would be a little difficult.
FIR and charge sheet not.
FIR alone. The charge sheet.
Yes. The trial of the case has not been.
The case has to be proceeded, or the trial must begun. Then because if it is only FIR, then it is treated as still under investigation. And if it is filed already, when the charge sheet was filed?
Charge sheet has been filed on 29/7/2022.
29/7?
2022, before the.
22 earlier?
Yes.
So trial not yet begun?
Not yet.
No process issued?
Not process issued. That's why I have not mentioned.
But.
Charge sheet on 39/2022.
39/2022.
Yes.
But then they must have registered the case under some GR. You could have mentioned because it is now pending before the court only.
Yes, before the.
Since it has already gone to the court, then we need to use record that number only, because it has to be quashed from that only, not from the police, because it is no longer with the police since after they have already submitted charges.
It has been forwarded to the learned Chief Judicial Magistrate.
No, that is why I'm saying, so this, even if it is to be set aside or quashed, then it has to be the case before the learned magistrate,
Lordship.
not the case in the process. Whom to direct? You need to mention your GR case.
Lordship.
Hmm.
I'll do it.
Because the GR case must be there. They must have registered by now.
Yes.
It must be under process, to issue process.
Process has not been issued so far.
So, but it must have been recorded. Now, where, whom to direct? Where to, what to cause? Because no longer with the police.
Lordship, page number 22.
What is that?
This is the.
This is final form. Charge sheet.
Yes, file.
Charge sheet on the way, it cannot be set aside or quashed. It has to be before the court. If it is a charge sheet.
Lordship, in the charge sheet itself, the police has filed before the learned Chief Judicial Magistrate.
Yeah, that is why then immediately after receipt of the charge sheet, they used to number it. That is GR number.
Yes, exactly.
There you have to mention. Unless that is mentioned, whom to direct?
I will mention it.
It's called general registering number. GR means general register number.
Yeah. So there is whom to direct. There is no way. You have to mention.
I'll mention by filing an additional appeal.
Then unless that is filed, it will be difficult whom to direct. Where from the record be called for? Which record?
Yes.
Unless there is a number.
Exactly.
You need to mention. The gate is listed on Monday.
Monday.
Now,
Monday.
if you have a number,
from
we can take up in the afternoon also.
Your lordship. I will try.
From tomorrow, vacation will begin.
Oh, sorry, Monday means next. It will go to next again.
21st. Till 20 vacations there. From 5 to 20 vacations there. High court vacation.
Lordship, it may be taken up in the afternoon.
You correct it?
Yes.
Yes.
Right.
We can do it. Oblige.
After, there's the last item.
Yes.
Yes.
Yes, my lord, I had filed my substitution application this morning. Substitution application.
Okay.
Substitute application.
Your file.
Yes, I am.
Where is it?
This morning, my lord.
This morning only?
Yes.
It has not come on record. Has it come? No. Okay. Your phone?
I am for the petitioner, my lord.
Petitioner.
Yes.
Mr.
The other one.
Learned counsel for the.
My lord, here in this case, on earlier occasion, this honorable court passed an order to deposit the due amount to the registry office of this honorable court. Due amount, security amount. Yes, yes.
Okay.
However, the said order has not been complied yet.
Substitution of which?
Petition of legal, yes, yes.
Legal year of respondent number?
Yes, respondent number 1.
One.
Respondent, yeah.
Okay, you are representing
I am for respondent,
respondent number?
sole respondent.
So one.
One.
My lord, I'm the petitioner.
Yes, so the respondent is no more.
No, petitioner is no more.
Oh, petitioner is no more.
Yes.
Okay, so they have to file substitution petition. Okay, Mr. And
The other.
the other learned counsel for the appellant, that he has during the pendency of this case, the petitioner.
Yes, ma'am.
Okay, petitioner expired. However, the right still survives, hence he has filed a substitution of the petitioner by his legal heir this morning. So the record is not has not yet been placed. Sorry, the record has not yet come. Stop. In view of the above, please this matter. That will be after vacation only?
Yes.
Okay, immediately after vacation, after the ensuing puja break. Okay, Mr. Kamo,
Yes.
Direct Counsel for the respondent is also present. Okay, let them file substitute their petition. Okay,
Bless.
sorry, the applicant. Yes.
Please, Your Lordship. Lordship, I think the lower court record is not yet reached, Lordship.
Okay, you are for?
I am for the petitioner, Lordship.
Okay, Mr.
V. Lord.
Direct Counsel for the petitioner is present. The trial court record. Is it trial court record? No, no. Okay, this is trial court record. We have received, I think. The scanned copy of the trial court record has been received. Stop. Page 4. And no one appears on behalf of the respondent. Okay. In view of the above, list this matter after 3 days. Okay.
All right, Lordship.
For respondent number 2, Mr. Aditya Agrawal is on BC.
Respondent number 2.
Lordship, I am for petitioner.
You are for the petitioner?
Yeah. Is it item number 11, Lordship?
Respondent number 2?
Yes.
And my lords, I am appearing on behalf of respondent number 2.
Mr. Agrawal is there on the BC.
My lords, am I audible? R2, my lords.
I am here to assist.
You are for?
I am for 2, just to assist the.
Okay. So who is for the who is for the petitioner?
I am for petitioner, my lord.
You are for the petitioner?
Yeah.
Yes.
My lord, this is the application under section 528 of BNS for quashing of FIR number 74 of 2024, dated 15 July 24, under section 318 of BNS, registered at PS Naharlagun. Actually, my lord, on the last date of hearing, dated 25th September, the Honorable Court agreed that this is not a criminal case and it is not justified to lodge an FIR in this case. Rather, it is a case of civil nature. And Honorable Court has directed the petitioner to appear before IO at Naharlang Police Station, and following the direction of the Honorable Court, the petitioner appeared before IO on 29th September and got his statement recorded, and the IO cross-questioned the petitioner in detail. Lordship, actually, in this matter, petitioner and respondent number 2 both are traders and doing business of steel kitchen equipments, and both have been doing business with each other since 2019. On 14th of May 2024, respondent number 2 approached the petitioner for ordering the commercial kitchen equipments. Petitioner prepared the quotation of the said ordered, and quotation was agreed by respondent number 2, and sum of 4,50,000 paid to the petitioner. And on 30th May 2024, respondent number 2 verified their order items and made balance of payment 4,50,000 to the petitioner and assured that he will pick up the item within a week. But when petitioner repeatedly requested to the petitioner, respondent number 2 to pick up the items because these items occupied a lot of space of the petitioner and this space is taken on rent by the petitioner. But respondent number 2 refused to pick up the items due to some reasons that the next order of him was cancelled with other party. And thereafter, respondent number 2 lodged the FIR against the petitioner and with the help of police started pressuring the petitioner to take the money back. Lordship, may I read the FIR? That is page number 13 of my petition.
He's not cooperating. Accused is not cooperating.
My lords, I may be allowed to make 3 humble submissions, my lords.
May I read the FIR, Lordship?
Just a minute.
Okay.
Who represents this respondent number 2?
My lords, I am. To VC, my lords.
You are for respondent number 2.
Yes, my lords. I have filed my memo of appearance, my lords.
Yes, where is the FIR?
Yes, page number 13 of my petition, Lordship. Page number 13, 1-3.
This is also same like your voice. Yes, please.
May I read? I, Krish Agarwal, address so and so, I have been running a business under the name of Shri Rani Sati Agency. I came in contact with the accused, namely Salil Pandya, proprietor of Yuvraj Steel Technology, who is in the business of manufacturing and supplying commercial kitchen equipments. Yuvraj Steel Technology, having its principal place of business at Kundli Sonipat, and further of his this and that. As per the term of the said quotation, an amount of rupees 4,50,000 was transferred to the accused on 14th May 2024. It was agreed between the parties that the rest of consideration will be paid at the time of dispatch, that is on 30th May 2024. On 28th May 2024, the accused contacted me and represented that the goods are ready for dispatch and that he is sending the e-way bill to me and further. Please, my lord.
Please.
Further, induced me to transfer the balance sale consideration as the goods were ready to dispatch. That believing that representation made by the accused to be true, I made another payment of rupees 2,50,000 via cash deposit and further an amount of 2 lakh RTGS on 30th May 2024 as the final payment in the bank account of the accused. Till 31st May, the accused was in regular touch with me. However, after taking an amount of rupees 9 lakh on the pretext that the goods are dispatched and the same will be delivered at my above mentioned address, the accused is not traceable, my lord. And I am under strong apprehension that I have been cheated by the accused to the tune of 9 lakh. That in order to safeguard my money, I made inquiries and sent my representative to the address of the accused on quotation address issued by the accused, that is Kundli, Sonipat, Haryana, and came to know that during the time of current transaction with the accused was not in the said business and illegally posed himself to be the proprietor of the above said firm with the sole intention to cheat me, had taken the above said order. My lordship, this is the allegation. My lordship, I am still ready to deliver the goods item, and I was ready to deliver the item from the beginning, but he refused to deliver. This is purely contractual relationship between the accused and the respondent number 2.
Why the CD was called? Just a minute. Why the CD was called? Mr. Tata?
Yes.
Why the CD was called? The case is still under investigation.
Yes. So far, it has not been charged yet.
Charge it filed or what?
As per report supplied to me, charges not yet been
Okay.
done.
My lords, I may be kindly allowed to make 3 humble submissions, my lords.
I humbly would like to submit status report of the IO. Status report of the IO.
Status?
There's a clear objection regarding the he's not cooperating, even not appearing
This is
when
petition.
My lords, I may be kindly allowed to make humble submissions, my lord. May pass the orders on merits. My lords.
Just a minute. Huh?
Okay, obliged.
Quashing of FIR. What is this 318? New DNSS.
420 of IPC, Lordship. 420.
The erstwhile 420 of IPC.
Corresponding, only 420.
Only 420, Lordship.
Why the status report was, why you are producing this status report? Whether
Yes. It was that
okay.
to produce the updated status report
For what purpose?
to ascertain the status of the case.
Okay. So, and what is this, the other document?
Other documents are the CD, case diary, and first document is a updated status report.
This is updated.
Yes. Comment may be highly kindly peruse front page. Front page comment may be kindly peruse. Comment of the IO.
So here in the quashing petition, the petitioner is also seeking bail. Or what? This is bail objection.
No, he's for quashing. Quashing of affair. Serious
Quashing of
objection in
FIR
this
and
regard.
also
This matter
also
may be fixed
production.
some other day so that I can come with, equip with some citation of the Honorable Supreme Court.
No, sir. See, this is submission of CD. By which other CD was called for? But it appears that IO has
25/9, 25/9, 25th September. It was directed to appear before IO also,
okay.
but
The
he
accused was
didn't.
directed by the IO to appear.
Yes, by this court to appear before the IO, but he didn't.
And this
Lordship,
court also
on
directed
20
for the direction of the IO, the accused should appear.
Following the directions of the Honorable Court on 29th, petitioner accused appeared before the IO at police station Naharlang, and I have
Whether you
filed my
appear,
affidavit.
whether the accused appeared before the IO of the case on 29.
Yes, yes, my lord. And
My-
I have
my lords,
filed my
but further-
affidavit. I have filed my affidavit before the
There-
Honorable
there-
Court
no,
regarding
this is difficult.
appearance
Intermittently
before the
breaking
IO.
of your voice.
Yes, Lordship.
Intermittently breaking of your voice. It's not clear. The affair is
My lords,
not
if I
clear,
may-
like your voice.
Lordship,
Lords,
Lordship,
if
may I
I may be
clear?
kindly allowed to make.
Lordship, may I clear? Lordship, on
Can't hear.
Lords,
29,
if I may be
I
allowed to
appeared
make kindly.
before IO at police station Naharlang. I have filed my affidavit also regarding my attendance and
No, no.
appearance. Kindly see my
Simple question.
affidavit.
Just,
That is
just
on
answer
record.
the question. Whether the petitioner appeared before the police on 29.
Yes, yes, my lord. Yes, my lord. Yes. I appeared
Appeared.
on 29th before IO. Yes, my lord. I have filed my affidavit also, my lord. Kindly see
Didn't
on
appear.
record. I have filed my affidavit
Because-
regarding my appearance
Didn't
before
appear
IO.
as per status report.
Wait.
As per status report, he didn't appear.
Okay.
He's not cooperating also.
Why
My
your
lords, he
voice
was
is also
further
different
directed to,
Section
he was
35.
further directed to appear on 4th as well, on 3rd as well. We didn't talk.
Wait.
Yes, my lords.
Who is submitting?
Section 35, subsection 3, BNSS is similar notice under all section 41A, 41A.
Sorry, 41.
Yes, appear before the concerned PS.
Okay, whether he appeared? No.
No, as per status.
As per the Learning Council, he appeared. Just a minute.
Lordship, may I submit?
Teacher. So the Learning PP Additional BP says that you did not appear, and
Lordship,
according to you,
Lords,
Lordship,
on 3rd, he did not appear.
on
He was further
29th
directed to appear on
September,
3rd.
I appeared before the IO. They are misleading the courts. Lordship, they are
Lords.
misleading the honorable court, and they are lying before the honorable court. On 29th of September, I appeared. Petitioner appeared with the counsel, and I have filed my affidavit. I have filed my
Lords, if I may be
affidavit
allowed
along
to
with
kindly.
my tickets, photograph of police station, and a mail sent to the SHO also regarding my attendance. Lordship, they are trying to mislead the honorable court and lying before the court.
Lords, they have only appeared on 29th. Again, the police directed them to appear on 3rd, but they have not appeared for the cross questioning and for the statements recording. They have only done so.
Respected elder brothers,
They are
I'm
misleading the
only
courts.
confined to my submission to the record only, not beyond that. I'm confined to the record.
Lords, if
I'm not-
I may be allowed to kindly make submissions on merits.
As per
but
he appeared through email.
He did not cooperate.
He appeared through email. Yes, and soon to be appeared. There are three of one IS there.
Salil Pandya.
Yes. There are four. Sorry, there are three. There are three.
When the FIR was lodged?
Page 63. It was lodged on.
FIR was lodged on which date?
Lords, 15th of June. 15th, 17th,
July 2024. 15 July.
July.
Now the case has not yet been charged sheeted.
Not yet.
Investigation not yet
Going on. That's why.
Lords, he has not cooperated only. He has only appeared for the 41A notice without investigation, my lords.
The case is still under investigation. How do we set aside and intervene the investigation of the police?
And also, my lords, I may be kindly allowed to make humble submissions on behalf of respondent number 2.
Okay.
My lords.
Difficult.
And my lords, he is misleading the courts. Let me allow to make my submissions. My lords, may kindly have my written arguments on behalf of R2. Ma'am, my lords, respondent number 2.
Respondent number 2. You have for respondent number 2.
My lords, I am appearing via VC for respondent number 2.
You are objecting.
Yes, my
Lordship, may I clear my
My lords.
Objecting there. I am objecting for. Okay. So this is today is fixed for
Admission, my lords.
it may be some other that may fix,
Yes,
so that I can come with equip the
unless you come practically and appear in person, it will be difficult from here because there is intermittently there is the breakdown of your voice and it's very difficult.
Lordship, may I clear my stand? Actually, Lordship, following the direction of Honorable Court, petitioner appeared before IO on dated 29th
Yes, sir, they are
September.
objecting, but they are objecting.
No, my lord, they are
filed
lying before the
Have
court,
you filed
my lord.
objection?
They are
My
lying.
lord,
I
they-
have filed my
Respondent, just a
affidavit, my
minute, just a
lord.
minute.
I have filed my
Just a
affidavit.
minute. Just a minute. Whether the respondent has filed objection. Respondent, have you filed
My
objection?
lords, yes, my lords, we have filed our counter reply on record.
Is there?
Yes, my lords, it's there on record.
Okay.
And my lords, may kindly have my written arguments. Just, my lords, give me 5 minutes. I'll just raise 3 points for the my lords.
We'll fix the date. We'll fix the date. You come and argue the matter. We'll dispose of on that day.
My lords, my lords, in the interim,
Here is interim. No. Is there any?
no relief should be granted, my lords. And my lords, maybe
My lord,
may kindly direct them to appear before the police
stay the
authorities.
arrest, my
My lords,
lord,
they have been
and
evading, my lords. My
and
lords, they have been
No, no, no,
stay
evading.
the
one by
proceeding,
one
my
by-
lord.
No, please, one by one.
My lords,
This
in
is
the
only
interim, they may not, my lords,
contractual
may kindly.
relationship, my lord, contractual relationship between the parties.
No, my
lord.
lords, my lords,
Business
I'll show.
transactions, no criminal intention from the part of petitioner, my
Lords.
lordship.
My lords, there has been criminal intention to cheat.
Also had Mr. G. Tador, Lani Council, Lani additional PP for the state, and Mr. Respondent,
Aditya.
what is your good name?
Aditya Agarwal, my lords.
Aditya, okay. Aditya
Agarwal.
Agarwal for the respondent number 2. Appearing on behalf of the respondent number 2. Stop. The landed additional PP has produced the status. The CD also.
status report as well as CD.
As well as the status report. Is great. When do you want to say? Is great for comma. List this matter immediately after vacation. Vacation. You want the fixed date? We can fix
Yes,
date
my
for
lords.
you. When do you want? When do you want?
Mr. Daya, it is directed to you.
Mr. Daya?
Any suitable date, lordship, any suitable date, but kindly grant me some interim relief, my lordship.
My lords, no interim.
Kindly stay the proceeding, lordship. They are harassing the petitioner, lordship.
October 22. Okay, let's pray for by the learning council for the parties. Come at least this matter again on 22/10. Okay. Mr. By then probably the police would. Then you also produce the updated case study.
Yes, CD may be written kindly. It may
On
be.
on which date the landed additional PP shall produce the updated CD.
It may be reflected in the order that CD is written.
Okay, return the CD.
Yes. I love it.
Hello, my lords, may one humble request.
Yes.
My lords, may in the interim may direct that police may take necessary actions for the investigation.
No, interim. The investigation will carry on as it is.
Okay, my lords, much obliged.
Yes. BA. Yes.
Yes, this is bail application. Lordship,
Item 13. Okay, 12. Yes. All right.
So I'll give brief facts first. Lordship, an FIR was lodged on 22/12/2017 on OCPS Sejusa. Lordship, after the investigation, after registration of the case, investigation, after the investigation, name of the accused person, the instant accused person came up. So after his name came up, your Lordship may kindly come to page number 24 of the bail application. 24. After his name came up during the investigation, OCPS Sejusa filed an application for NBWA, as his name was not there in the FIR. Only after the investigation, his name came up. So accordingly, NBWA was issued, and he was arrested and produced before the Learned Chief Judicial Magistrate SEPA, page number 25.
The 24 is?
24 is the application by the OCPS for issuance of NBWA, which was allowed, and NBWA issued. On the strength of NBWA, he was arrested and produced before the Chief Judicial Magistrate SEPA on 7/6/2018. It's in page number 25.
Page, what? Page 25. What
Yes.
is this?
And
He was produced. He
Produced.
was arrested.
Yes, arrested
Okay,
and
on the
produced.
basis of in execution of this NBWA, he was arrested.
Arrested
And produced before the court on 7/6.
7/6/2018. Now, after that, he was produced, he was in the custody. Later on, he was granted bail, and the instant case was transferred to as it is session tribal case. It was transferred to the session court, Bombila.
No. After production,
He was in the custody, judicial custody.
Okay, then filed bail.
And he was released later on, and he was the case was transferred to session court, Bombila.
The bail was granted.
Yes.
Bail granted to him.
Now
Transferred to?
Yes,
Case transferred to which court?
session court, Bombila.
Okay, so this was by the CJM.
Yes.
CJM.
CJ.
No,
CJM, which court?
Session Judge, London Session
SEPA,
Judge.
SEPA. Okay.
Chief. Now the important part.
Yes.
After that, page number 28. Page number 20.
Yes.
In session court, Bombila, the defense counsel was absent, and the next date was appearance for next date was given.
Okay, trial began.
Yes.
Charge also.
Trial already
He was
began, and
charged
he has
under-
been charge sheeted and
Charged under 302.
302, 34.
And with others.
Other co-accused are
Arms act also. 25 only. Arms act.
Arms act also. It shows 302 only. Yes, then what happened?
Now, after that, Lordship, someone was issued for his appearance.
Okay.
Now, the surety, earlier when the bail was granted by Chief Judicial Magistrate SEPA, the surety, the then surety already passed away, and he never received the summon. So, without considering that, on the next date, in his absence, an NBWA was issued by the Session Court, Bombila, page number 29.
Yes.
NBWA.
Yes.
Now, it is, your Lordship may be aware already that in the Satyendra Kumar Antil case, the procedure after the execution of BAW,
Someone earlier issued, not issued.
Someone issued, but not
Someone
BW.
issued on 22/11 also.
On
Someone
22,
issued.
someone issued
On non-appearance probably.
Yes, exactly.
And
But
BW
now the part.
Available, you want, yes.
BW should have been issued.
11/19.
Yes.
Someone was on 22/11/19.
Someone was issued, and on 27/1/20, on the non-appearance of the accused person,
27.
NBWA was issued.
So then, of course, it's available, it should have been available.
Yes, bailable. And after the execution of bailable, if he fails to appear, then NBW should be issued. It's clear. There is no dispute on that. But NBWA was issued on the strength of NBWA.
Then what happened? Whether the NBWA executed?
He was arrested by the Assam police and produced before the this session court on 10/1/2024. Now it's page number 30.
Yes.
Yes.
Sub-divisional magistrate.
He was arrested at Assam, then produced before magistrate and then brought before.
Then what, then what?
And since then he is in custody. And a bail application was filed. Lordship may kindly come to page number. Or page number 31. Lordship, this is the bail application. Bail application, it was rejected, though the counsel for the accused person has clearly stated that the surety, the then surety, has already passed away, so the notice issued was never received, and the summon issued to him was also not received.
He was not cooperating. That was,
yes,
that is why
but
it appears the Garnet session judge.
But someone, if someone has received, then
what is the progress of the trial? Whether
it's already been charged sheeted, CC has been completed. Now he's in custody for almost 260 days. Now, keeping someone in custody mainly for investigation purposes, where there is a chances that he will hamper the investigations. There is co-accused also. They are untraceable yet. So the proceeding has been split and
already charged it. An incursion period at this point of time is not material. Incursion period, whether if there is promise made out against him, there is no violation of any Article 21 Indian Constitution.
I am into lordship that the whole procedure itself is incorrect. First, BWA should have been issued. Now, this is a clear violation of Article 21. And after lordship, there are other co-accused as well, but the proceeding has been split and he has been charges is framed against him. Now he's in custody for more than almost 260 days. There's no purpose in keeping him in custody. He should be given a fair chance to defend himself.
There's a pattern of rulings of Honorable Apex Court that incursion period is not material. Even in Papu Yadav case also, he remained stay for six years.
When the bailable BWA was issued, just
no BWA issued, direct NBWA issued.
Someone was issued. Issue fresh someone. Present 19. 22 11. Someone was issued earlier
Yes.
also.
Lordship,
Second someone.
Place a judgment, Your Lordship.
Third someone. So no. Second, after issuance of second summon, then straight away.
Yes.
After first summon, it should have been the second summon should have been, of course, issued. Available of BWA.
And this has to be considered, Lordship, the surety to whom the notice was issued. He already passed away. As such, he couldn't receive the notice. Now the instant applicant is the brother of the accused person, and they have same residence. So, and he's willing to cooperate, and there's no chance that he will jump the bail or abscond.
No, the court have been issuing NBWA since 3 occasions, I think. Issued.
There's Lordship,
on 27, 120, 23, 320, and 6, 5, 20. Nine, 4, 21. 2, 2, 21. No, so in so many dates.
Yes, NBW was issued, sure, Lordship.
No,
and it's
so many occasions. No, since 2020.
Because
January. to see these NBW issues time and again, and the same could not be executed.
Yes, could not be because the then surety already passed away and they couldn't trace it.
So many dates, so many dates. Even if the NBW issued also earlier, 3, 4, 5 times also, you were
Lordship-
not found, but then ultimately NBW, of course, but then that cannot be the pick
Lordship-
now at this stage.
I have
Because NBW issued for over 10, 10 times.
BW should have been issued, and if it was not executed, they continued to be issued BW. And after the execution, if he fails to appear, then NBW should have been issued.
No.
Lordship, I have
NBW, since. No, since then the court has been issued. No, issued.
there is no dispute on the fact that NBW.
And even the BW.
No, BW.
BWA to the sureties. And BWA to the accused and BWA to the sureties. Is 15, 16 times it was issued. See, all the same. You're for Pranjit Thapa and Anand Tante. Anand Tante.
Other co-accused are still unable to trace.
Because by seeing the record, probably the court has not granted bail also. Because unless you cooperate for trial, then the court would keep you and proceed the trial by keeping you inside.
Lordship.
Because time and again, the court cannot keep on issuing.
That is why.
Again and again, no. So when the court finds that the accused is not cooperating, and next time also he is not going to appear, then he will be kept under custody.
If the learned session court has issued one BWA also, that may have twice, then he is not cooperating, then NBW, it can also be understood. Lordship, but in this case, BWA was never considered. And procedural, Lordship, I have submitted a judgment until it's clear that someone, then BWA, then NBW.
Who is this Papu Orang?
He is the brother of the surety, then surety.
Not the surety.
No, he was arrested and brought before. The surety already died way back. Due to some confusion, he was brought, and after that only they were able to.
Connected in other cases also in Assam.
Hmm?
Connected in other cases also in Assam. Connected in other criminal cases also in Assam.
Okay.
Golagat case.
The present one.
Yes. Yes.
So
that is why, in order to ensure his attendance, he has been kept
As
inside.
such, now the applicant, instant applicant, is the brother of the accused person, and the address, he has address, they are of the same address, and they are willing to cooperate. For that, he may be granted bail so that he can defend himself. Keeping in custody, Lordship, it's unreasonable.
The other accused not yet arrested.
Other accused are not even arrested. The proceeding has been split and he has been charged.
So the trial is proceeding against the present accused.
Yes.
Then you say,
and he is willing to cooperate with the trial.
The
Proceeding can be go on after splitting of the case.
He has been charges.
It can be go on, but not released now.
See, under the circumstances, the trial court is the best court to decide whether he
Exactly, you're
should be released or not. Because finding you not appearing before the court for so many years, it's, I think, around more than 2 years you did not appear.
Because
Although NBW has been issued time and again for about 20 times. Every month they have been issuing the NBWA.
that is the law.
And that also could not be executed for such a long period. And that is why
There is no
probably
denying on fact, because
now-
they couldn't trace it.
now also it appears must have observed. Let us see in the observation. What is this?
Satyendra Kumar until judgment. Page number 17, 32. I've marked it. Flag has been.
Now see that during trial, the trial court is making all endeavor to complete the trial and dispose of the matter. And then if you don't cooperate, naturally, you'll be kept inside during the trial period. Whoever, have you
I
marked?
have marked it. 32.
There are
32.
there are 32. What it says?
It says, considering the aforesaid two provision, court will have to adopt the procedure in issuing summon first, thereafter a bailable warrant, and then a non-bailable warrant may be issued if so warranted, as held by this court in Inder Mohan Goswami versus State of Uttaranchal.
No, here the case is different, it appears. Because NBWA, he has been issued for 20 plus time.
BWA was never issued. Summon then directly in NBWA.
What's the difference? Because the NBWA could not be executed for 20 times, for 2 year plus.
Lordship, but procedure says.
And you are speaking on that.
Yes, but procedure says that BWA should be, and if executed, then he could have appeared at after execution. No need to keep him in custody. Now directly NBWA was issued.
Now, since you have been remaining absent for such a long period, and then even after, despite of all efforts, the police could not execute, and more than 20 NBWA issued against him, then how do the court expect that you will cooperate now? It will be difficult. The court wants to keep him and then try.
He is willing to give
complete the trial.
Surety on his brother, the applicant earlier, the then surety, he passed away. Because of that, he couldn't receive.
Now this surety is there.
This surety is the brother and residing in the same address. Brother of the accused. The accused is Babe, the applicant.
Where have you annexed the bail application? Sorry, the bail order. Where is the rejection order?
Rejection page number.
You have annexed only one NBWA. Page number?
Page number 31.
Page 32. Second. Repeatedly summoned for 5 years and one of the issue.
Okay, this was not clear. He has remained absent for last 5 years.
Yes. His 5 years repeatedly been summoned and one was issued like this.
So he is involved in Bokakat PS case, involved with arms sector also.
Yes, that's in Assam case.
Then even if you are released also, you will be arrested there. Hmm?
No, sir, bail was granted on that. He is already on
Okay,
bail.
he's on bail in that case.
Yes.
Now,
Yeah.
since you are not cooperating there also, then probably they will keep you again. Must have issued NDWA.
Here, offense involved is heinous in nature, 302, and even the concealing of evidence, 201 IPC. And section 34 is also there.
Okay. So we'll take up after.
My humble prayer before this court, it may be rejected. This bail application may be rejected.
Okay, just let me record a fact. Heard Mr. Siri, Land Council for the petitioner. I've also heard Mr. Taro, ADPP, for the state staff. This is an application. Bail application under 83 of the Bharatiya Nagarik Suraksha Sanhita, section 439 of the for criminal procedure, praying for release of the accused person on bail in connection with session case number 0819 arising out of CJOSA PS case number 10/2017 under section 30234 IPC. The case of the petitioner is that the accused petitioner was arrested when he was arrested?
He was arrested earlier.
Yes.
8/5/18
or 19?
Sorry, 7/6/2018.
7/6/2018 in connection with the Joseph PS case number 2017. And subsequently, the accused was released on when?
That date I'm not aware of. Exactly, because it's not in the record.
Not in the record. Instead of that is necessary, we need subsequently he was released on bail. Stop. It is submitted that after completion of the investigation, the case was submitted in the charge sheet before the SEPA, before CGM, before the CGM SEPA, who then had committed the case before the session court, Bomdila. So after the in session court Bomdila, stop. But thereafter you never appeared.
No.
Okay. So Bomdila, where after taking taking cognizance from the learned session court had issued a summon against the accused petitioner for his appearance. Stop. However, the had no knowledge about the issuance against the accused had no knowledge about the issuance of summon against him by the session court at Bomdila. In the meantime, his surety also died long back, and therefore he had no any information regarding the issuance of summon against him. Hence, he could not appear before the court. So, thereafter, the learned trial court, without issuing, where you have stated that it is not issued bailable offense, where have you stated in the paragraph in the petition?
Paragraph 11.
Paragraph, what you have said?
Moreover, without considering the issuance of BW against the alleged accused, the learned.
Okay. Thereafter, the para 11. Para 11.
Yes.
Thereafter, without considering the issuance of bailable warrant of arrest within bracket BWA against the accused petitioner, comma, the learned session judge directly issued NBWA against NBWA non-bailable warrant of arrest within bracket NBWA against the accused applicant on his non-appearance before the said court. Stop. The Atlantic Council for the Petitioner submits that on non-appearance of the accused after issuance of summon, comma, the London Session Court would have issued a bailable warrant of arrest against the accused for his appearance. However, the London Session Court has directly issued NBWA against him for his appearance, which is against the procedure. Stop. In support of his submission, the London Council for the Petitioner relied on the decision of the Honorable Supreme Court in case Satendra Kumar Antil versus Central Bureau of Investigation reported in 2022 0 Supreme within bracket SC bracket close 588. Is this the one? The relevant paragraph is quoted below, reproduced below. Which paragraph 32? 32. 30. This long one, I think. This para 32 quote. Para 32, entire para 32. Yes. What else?
Entire pair 32, 50, the same line. Observation.
50?
50 also. Just
Para
after
50?
32. Just after 32, it's also 50 is also there.
What 50? Just after how? 52, no? After 30 to 50. Para 50 also?
Yes, in the same line.
The same line? No.
All is related to issuance of non-bailable warrant.
No, this is within 32 only. This
Yes.
50. So in 32 itself quoted the quote in Inder Mahan Goswami versus State of Uttarakhand. The quote is 51. 50. It's continuation of 30.
Continuation.
The Council for the Petition submits that Oh, the applicant is not the accused, not the accused.
No,
Okay,
applicant is the brother of the accused person.
okay. Then it will have to be changed. The Lara counsel for the petition submits that the applicant is the brother of the accused, and he has undertaken to produce the accused agent accused before the court for trial, agent when called for. And since the brother, since the petitioner has is ready to stand as a surety, having he is a resident of permanent resident of
Village Kalakua, Bokapat, District Golaghat, Assam.
Okay, permanent resident of which village?
Village Kalakua.
Kalakua,
POPS, Bokapat,
Kalakua, Bokaka district.
District Golaghat, Assam.
Bokaka district, Golaghat, Assam. There is no possibility of the accused. Just a minute. Okay, just leave that. The petitioner is the brother and resident of that address. He has undertaken to make the accused available before the court for trial, and before the court for trial, as and when called for. Stop. The accused has also undertaken to cooperate and appear before the trial court, and as he is staying with his elder brother at the given address, there is no possibility of his absconding. Okay, stop. Sarah. Mr. G. Tado, additional PP on the other submits that the accused remained absconding for about 5 years after submission of and never appeared before the trial court. Therefore, the learned trial court had issued NBWA against him. Against him. Start. And since the accused is from outside the state and had records of not cooperating with the court, there is a possibility that the accused might abscond. And then there is a possibility that accused jumped bail and remain absconding. Start. The Learned Counsel for the Learned additional PP for the submits that the accused is also involved in some other case in Assam. So therefore, he has vehemently object grant of bail to the accused till the completion of the trial. Stop. Both the Learned Counsel for the parties. I've also considered and also peruse the trial court record and consider stuff. So, since the accused has been arrested in execution of the NBWA issue by the session court, sorry, just a minute. It appears that On non-appearance of the accused, the Lanet trial court has issued NBWA, and in execution of the said NBWA, the accused has been arrested. Stop. The contents of arrested. The contents of the land counsel for the petitioner is that after issuance of the summon, on its non-appearance, the land trial court would have issued an available warrant of arrest as per the procedure. However, the land session court directly issued NBWA after the summon stop. After issuance of summon stop. Okay. Which is against the procedure. Upon hearing, upon the parties, I find sufficient force in the submission made by of the land counsel for the petitioner. Accordingly, sorry, just a minute. In view of the considering the submission made by the parties and also considering the decision of the Supreme Court in decision of the Supreme Court in Satendra Kumar Antil versus Central Bureau of Investigation within bracket Supra, I'm of the opinion that the accused can be granted bail. With certain conditions. Stop. Accordingly, this bail application is allowed. The accused is directed to be released on bail on execution of a bail bond of rupees 20,000 with two surety of like amount, one of which should be a resident of Arunachal. With the further condition that the accused shall cooperate and appear before the trial court as and when called for, and that as and when called for. That's enough, I think. With the above, this bail application stands disposal. Okay.
Public.
215. 15, huh? I think 25. Yes.
May I please?
Yes.
Earlier I have not retained the GR case number, but now I have inserted. There is 686.
Okay. Mr. Land counsel for the petition.
For online printout of GR.
You have to insert here somewhere. Okay. Done.
686 of 2023.
Okay. This is an application under section 528 of the BNS from 2023, praying for crossing and to set aside GR case, GR number
686.
2022. Arising out of Mahalam PS case number 103/2022 under section 120B 419 420 IPC. Pending before the court of the Chief Judicial Magistrate Capital Complex, UPR. Start. Hold for the scan copy of the see at this year side code record issue notice. So returnable by 3 weeks.
After puja
After
vacation.
vacation, it will be 3 weeks. Okay, start. Since Mr. Tado has appeared. Okay, only the state is the respondent.
Yes, Your Honor.
Okay, on behalf of the state respondent, G. Tado, additional PP appeared on behalf of the state respondent. No notice, a formal notice need be issued. Start. Please this matter. After 3 weeks.
Lordship, my interim prayer may be considered.
See, the interim without GR, where to stay? What to stay? Okay. In the meantime, it is provided that the further proceeding of the of proceeding of the GR case number 686/2022 under section arising out of Naharan PS case number 103/2022 under section 419, 420, 120 IPC shall remain state if the returnable date, next returnable date. Okay. Okay. Yes.
Yeah, Lordship.
Yes.
Lordship, this is a bail application. Yesterday we did little part heard.
Part heard?
Yesterday, Lordship.
Okay.
The matter is fixed for today for final hearing.
What is this matter?
Bail application, Lordship.
Bail application.
Yes. So,
Why divorce case is part heard?
Lordship. Lordship, this is a case diary, Lordship. Case diary, Lordship.
Okay, for case diary.
Lordship.
Okay.
May Lordship, may go through the statement of the accused, Lordship. Here is clearly admitted of his offense. It is statement of the accused who is arrested.
Just a minute.
Was with the NDPS case under section 21B.
So, what was the allegation against the accused?
FIR is on page 22.
The accused was arrested on the spot.
Lordship. It was a Naka lordship. They have previously have informed by the on the relevant sources lordship. Thereafter, during the Naka, he is by search warrant, he has been searched by lordship by producing the notice before lordship. After that, the search was done, and he was arrested on the same day.
Okay, only the timing.
Lordship. Yes, lordship. Timing is there, lordship. But lordship,
So
timing.
So the problem was with the timing.
Lordship.
That the seizure was made before the arrest, or before Naka.
No, lordship, it was lordship. I have spoken to the OC of the concerned station lordship because IO is on the leave lordship. As per the OC, there's lordship, two seizure lists was there lordship. The one is at 2 a.m. lordship or 2 p.m. which lordship was about that asked me to query about that 2 p.m.
Yes.
Lordship, yes, lordship.
Why he has recorded as 2?
Lordship,
Because
that is
at 2 he was
there's a man, as per the lordship, OC is simply clerical mistake, lordship. And that cannot be denied. As a possession is lordship, we recover from the accused person. On this timing factor, lordship. But 2:30, lordship, one seizure is also there was a 2:30.
because after that,
Because
normally what happened is that because immediately at the incident,
Lordship.
while Naka, they don't write.
And lordship, this is all the method of trial, lordship.
Brought him in the police station, and then they reduce it into writing the FIR, etc., etc. So then it is just construction
Lordship.
of the thing.
It is a matter of trial. If the possible, IO can appear before the lordship concerned court and they give their statement, lordship. It is a matter of trial. For that reason only, their bail should not be granted at this stage.
It's not only about the time,
become
completing
callous.
time, Lordship.
Yes, lordship. And lordship, moreover, lordship is arrested on 31st of August, lordship.
How many days he has been inside the custody?
Today will be, Your Lordship, 35 days.
35 days.
35
What is
days.
the max? What is the punishment?
10 years, lordship.
10 years.
10 years.
Lordship.
So it can go up to
Up
10
to
years.
10
Yes,
years,
lordship. But the 60 days, lordship, at least.
How many days you said?
35, Your Lordship.
Oh, 35 days.
As of today.
Okay.
And lordship,
So-
lordship may go to this status of this lordship, that investigation lordship. Accused person is not cooperating in the investigation process also.
He is in the custody.
He is custody, but he is not
How he is
cooperating.
not cooperating?
Oh.
Lordship, as per the statement of the IO lordship, he is not cooperating. Maybe lordship because he's drug peddler. Maybe
He is
he's
not cooperating.
lordship.
He is running away from custody.
Yes, lordship. Not as per his statement, lordship. You go to this case diary, lordship. I have plaque mark in the yellow color, lordship.
You cannot compare that way. If he has not done.
Maybe he's not revealing the name of the other co-accusers, lordship. That could be possible.
He is clearly
Lordship,
stated here.
in the page, lordship, this
He has purchased
yellow
from
plaque
Dimapur-
mark I have,
Purchased from Dimapur, Nagaland.
lordship. This will.
Previously also, he has revealed everything, I think, NDPS, different occasion.
May I submit, Lordship?
Yes.
Lordship, by reading the plain FIR, even if we believe that first of all, the police have did the procedure and after that they reduced that FIR into writing. But in the FIR itself, while they were placing their Naka checking, before my apprehension, before my interception, they asked two independent person to be act as an independent witness.
What?
They stopped two person to act as an independent witness during the process of their police search and seizure. But Lordship, the place is also crucial. They said that it's near the Sunday market area. It's a market area. There have to be people around. But they were stopped two person prior to my interception, and they asked them to act as an independent witness. And
So how you are agreed by that?
Lordship?
Because how you are agreed by that?
No, I believe, Lordship, that if the witnesses
Because
are,
they knew that you are coming, you are on the way.
but there's a credibility is in question, no,
They
Lordship.
received an information that you are coming, you are on the way and reaching.
But their
That is
credibility,
their arrangement as a police.
their credibility may be in question, Lordship, about the
that-
independence of the witness.
Yes, that can be questioned. They
And
try.
and
Because you demolished.
Lordship, that's the first point. After that,
During cross, you bring it.
and the informant is also ASI, Lordship. There was police personnel from the same Thana.
So,
And And timings are different in
Anyway,
every
what
document.
is, disposal, bail will be rejected.
Lordship,
So no time, bail will be rejected.
Lordship,
At
then
this stage-
a date may be given.
Yes,
Then
yes, yes.
I may,
I've seen the record.
I may submit some citations of honorable courts if your Lordship permits.
If you want, but that will not help in this case.
Lordship, if your Lordship just grant me little time.
What is the citation?
Lordship,
What is the citation? What do you want?
no, there are several judgment and several observation of different high courts that.
Yes, yes, yes.
That the section 52A is also.
I've seen the records.
Lordship, 52A is also not complied here.
Everything is complied.
52A is also not
They
complied
received
here. Lordship,
all
if
the
we see in the.
information, they have even, you see, informed the ADC also.
Lordship.
So
Lordship,
everybody was ready here.
but
They
then.
have served notice also, Lordship.
And then they cannot be, you see. So in the presence of ADC and all those officers, they cannot just play with, and they cannot.
But there are irrelevancies in the time, your Lordship. Then.
Yes.
Then if we believe that after all the procedure they have written it down, then those times are then manifested one.
See, ADC boardroom.
ADC boardroom, your Lordship, yes.
So he also accompanied because after receipt and thereafter only you reached. There is a clear case. Anyway, the bail will be rejected.
But let's
Bail
hope the detention period is also today's 35 days.
35 only.
35 days, Lordship.
35.
And an investigation might also have been completed by the police during such. I was also remanded to the police custody for 3 days, Lordship. 4 days, sorry.
Naturally. Okay. Mr.
Be duty, Lordship.
Planning Council for the petitioner. I have also heard Miss Elagi, planning additional PP. So this.
Lordship, then.
Because there are other methods also.
Lordship, a date may be given then.
Date?
For proper citation and.
After rejection?
No, without rejection, Lordship. After that, the final order should be passed by your Lordship.
You want to? You want another date?
Another day, Lordship.
Lordship, for what?
Just for the.
Lordship, for what purpose for the
Just for
another
that,
day,
your Lordship.
Lordship?
I may able to collect some citation and consult with some seniors, Lordship, about the matter connected here.
Lordship, it is a bail hearing, Lordship. Already everything is in record, Lordship. And it's merely 35
Because,
days.
your Lordship, according to my understanding and according to my knowledge, I see this, there are severe irregularities.
Pray provide the Land Council for the petitioner. List is matter after the puja vacation.
After vacation, Lordship. A date may be fixed, Lordship. A date may be fixed. Date, Lordship.
When?
After puja.
Better you take after 60 days.
Lordship.
After 60 days, expiry of 60 days. 35 days.
Yes, Lordship.
Now, better you take after 60 days. It's better. When do you want, man?
22, 23, Lordship. 22, 23.
22.
That will be more than 50 days, Lordship.
More than?
50 days.
50 days. So, okay, 28. That will be more than 60 days. Okay.
Lordship.
Is prayed for by the Land Council for the petition. This is matter on 28 October. Okay.
Obliged.
Yes.
My lord, this is a bail application.
Yes.
Filed under section 483 of the BNSS Act. Rank for releasing of the accused person in connection with rank for releasing of the accused person in connection with WPS case, Itanagar. My lord, the FIR. Kindly find the FIR is a page number 16. Page number 16. May I read out?
Page
number 16.
16.
Yes, 16 of my petition. Page number 16.
Yes.
May I read out the contents of the FIR?
Yes.
To the police officer in charge police station Itanagar. Subject FIR against Ms. Munibagan under section the child trafficking. Sir, with the humble submission, I would like to inform.
I think you
Page number 16. 16.
Can you don't spell out the name? Probably it's child trafficking.
No, it is accused person.
But this is accused.
Yes, Mimi Bagam is the accused.
So in there also, name of the victim may not be taken.
Okay. I would like to inform you that Miss such and such, daughter of the late Lebon the Dabam of the Pinchi village under Kurungkume was stay with me at Shinkivu Itanagar in residence of my elder brothers, Sri Kipa Logu. Miss such and such age about 16 years was suspiciously missing from home at around 7 p.m. to 7 p.m. on 9th June 2024 from our resident, Sankivu Itanagar. After searching all around in the colony, we could not find her. Then we asked one of her friends called such and such, and she told us she might be there at Ganga village. Then myself, along with my brother Kipa Palang, and Miss such and such left for Ganga village to trace out her. As and when we reached to Ganga village at around 10 to 11 p.m., Miss such and such made telephonic call an unknown person bearing mobile number such and such. Thereafter, she brought us to rented house of unknown lady called Miss Mimi Bagang, accused person man, at around 12 midnight. And Miss such and such victim was there with her. Since then, made interrogation to our sister, Miss such and such. Now she reached to unknown lady rented house and came to know that she was planning to go to Delhi under the guidance of Miss Mimi Bagang, that accused person, the region unknown. Miss such and such and her parents are very unknown to Miss Mimi Bagang, that accused person. Why she had met all arrangement to go Delhi. On this suspicious situation, we brought her and Miss such and such to your police station at around 1 a.m. for preliminary investigation. It is come to understood that Miss Mimi Bagang was planning to traffic these underage girls to Delhi in order to enforce them sex racket and other illegal activities for her benefit. She might be the regular child traffickers, sex workers, and smuggler. That is the authentic reason. She, Mimi Bagang, kept my sister in a rented house. Therefore, you are requested to register the FIR under sections 376, 370, 370A, 363, and 120A of IPC. This is the my lord content of the FIR. But in the actual fact of the case is, my lord, this accused person is totally innocent in this case.
This is,
Yes.
what is the name of the accused is?
Mimi
Where-
Bagang, there is 5 accused, man.
Okay, and then
5 accused.
you are for?
I am for the Mimi Bagang, and Mimi Bagang accused person is a lady. Other accused is a man.
So in the entire, almost entire FIR, her name was coming.
Yes, entire FIR was in my name. But after investigation of the case, it was revealed some other things. And my lord, case IO has already been charge sheeted the case, and call record has been called by this honorable court. Already charge sheeted.
Already charge sheeted.
Charge sheeted, and cognizance has been already taken up.
Okay, then trial.
Yes, the trial will be begin from
It will commence.
Yes, commence.
Okay, then accused must have been someone.
Yes.
Issued the
Someone
possession
had
warrant
sent-
must have
yes.
been issued against accused.
Yes, yes.
Okay, then why you did not file bail application before the trial court?
I was
Because-
filed, yes, my lord. I was filed 2 bail application before
You
the.
filed?
Yes, but
2
then-
bail application was.
2
so
bail
the-
application.
The last
Earlier,
application-
initial stage.
The last application was, last
Application was
rejection
filed on, it's annexure number 3. man.
Election 3, page.
Page number 33 of my petition. This is the
23.
last bail application.
23.
Yes, 33.
33.
Yes. It was rejected, this citing that no ground is there. At the same ground, I have filed the same. That's only it was rejected. And now the accused person is in judicial custody for the 98 days now. And my lord, may I peruse the CD, charge sheet? The statement of the victims. 164 statement and 161 statement.
Without wasting of this honorable court, valuable court, time, Section 40 of the POCSO Act, legal aid has to be provided to the victim. And step I have already taken, and that report I have submitted before. Legal aid counsel under Section 40 of the POCSO to be appointed. She is under care of ITA WPS OC.
Okay, no one represent,
No,
not yet appointed,
not yet appointed.
but then,
Section 40 may be invoked.
Legal aid. Already I have take step to the victims through police.
through OCPS.
OCPS through,
Through
it was directed to take step through the PP. And I have accordingly taken the steps.
Now then, no, sorry, they are from, it appears they are from outside.
Yes, OC
The
ITA is.
counsel need to be appointed.
Earlier through bail
Hard
application, the
Mr.
victim was appeared.
Okay, Lord Mr.
Tilam.
Land Council for the petitioner. Also hard Mr. Tado, addition PP. No one appears on behalf of the respondent number
2 and 3.
2 and 3.
Yes, there's 2 victims.
2 and 3.
2 victims.
No one represent the victim, respondent number 2 and 3. It appears that the respondent is where the respondent victims are at the moment presently.
As per record, they are under the care of OCPS, ITA Home and PS.
They are from outside and okay, just leave that. No. So, whether someone was served to them.
Yes.
So notice. Okay, it was given, but
Along with the
whether
photocopy of the bail application.
One 10/24.
Okay. Although step were taken upon the respondent number 2 and 3 through officer in charge of Women Police Station, Canada. However, no one appears on the no one appears on behalf of the respondent number 2 and 3. So, in view of the problem, the registrar stroke secretary High Court Legal Services Committee shall appoint one legal aid counsel from the panel advocate of the Legal Aid Council of the High Court Legal Services Committee to represent the victims within bracket respondent number 2 and 3. Least this matter after the ensuing petition. Okay. Okay.
Sure.
Yes.
My lord, particular date may be particular date.
Particular date?
Yes.
They need to appoint first. Let them appoint.
Actually, that accused person is innocent in this case, and now she has been in judicial custody.
Why particular date? You're here only.
Yes. That October the 21. Just
October?
after vacation, just after vacation, the 21.
Yes, after vacation?
Yes.
No, because there will be vacation only. And during vacation probably, because today is the last day,
Yes.
they may not take steps. Because it will be vacation only. Thereafter only probably they will take steps.
That office will be remain open.
How do we remind? Because from tomorrow it will be vacation only. You have come on the last day. This has been fixed on the last date. Why you got this matter fixed for today? On the last date, we'll fix on the last after vacation. That is also after vacation. It will be 3 weeks. Because we have to give time to the registry also to take the steps. They have to call the council to appoint.
Yes.
We are going to appoint you. So for that also it takes time. Thereafter they will have the records.
That
of all
was
those.
23 of October. It will take 1 day only.
No. So after the first week of November it will be.
My lord, this is very long. Because already accused person is
30 October. Okay.
much obliged.
Extra copy may be served to the legal aid.
Then because you have to serve copy also then.
Yes, I'll sir.
Okay.
Much obliged.
Yes.
Item number 16, was it? Okay, in this matter, was it interim?
Item 16. Oh, this is 16. Okay, yes.
In view of interim order dated lawsuit, 2609 lawsuit.
Okay.
2024 lawsuits, petitioners appear before the eye of the case lawsuits and given the statement. And lawsuits, today lawsuits, series all for lawsuit.
This is a purely lawsuit. Just to actually to see what about the interim order.
Dated 26/9.
Yes.
26/9/2024.
You appeared.
Yes, lawsuits. Appear on 29 lawsuits. Yes.
What happened thereafter? You have the record.
This is lawsuit purely a civil matter lawsuits.
Purely what?
Civil lawsuits, civil dispute lawsuits.
Hmm.
Because lawsuits, after filing of this FIR lawsuit, again.
Then let us see the FIR
complainant-
just once. Let us see just quickly the FIR once.
Once lawsuit, FIR is annexed lawsuit 4 lawsuit. Type copy, page number 19 lawsuit, type copy is at page number 19 lawsuit.
Oh, long one. The forgery, cheating, so false, cheating. Yes. What is there on record? So you have the record of appearing before the police?
Yes, lawsuit.
Where?
Basar lawsuit.
No, where is the record?
Record lawsuit is a statement lawsuit, even lawsuit.
That's
Where?
a CDN status report.
Status report.
Yes, he present before the IO concern on 29/9.
Okay, then thereafter.
Interim
so
was
arrested.
granted on
Was he
26/9.
arrested?
Yes, as per executing the all formalities, doing all formalities, he was arrested and released on the
Where do I
strength of.
find that? Bail executed.
Yes,
Bail also executed.
yes,
Okay. So where do we,
on the strength of
Fine.
interim,
hmm?
on the strength of interim, bail was executed.
No, where do we find that record? That he appeared on such and such date?
Status, past second page, status report, down below last 2-3 lines.
What name of the accused is Libom Boje?
Yes, lawsuit. Libom Boje lawsuit.
417 and 420 IPC.
heard Mr. Land Council for the petitioner. I have also heard Mr. Taru, Land Elson PP for the state staff. This is an application. Praying for grant of pre-arrest bail. In the application under section 482 of the BNS S 2023. So 438 of CRPC. Praying for grant of pre-arrest bail, apprehending his arrest in connection with Nahalagan PS case number.
Sorry, this is the probability of Basar Lossi.
Basar?
Yes. In Periyar Lossi.
Why, what is this then, Nahalagan?
Nahalagan Lossi, typography irrelevant. Mistake Lossi. Lossi, in Periyar portion Lossi.
Periyar portion?
Yes, Lossi. Basar Lossi.
Don't do that.
Sorry.
Don't try. Complete. Basar?
Yes, Lossi.
And number is also
same Lossi. Number same.
Same?
Yes, Lossi. Number same Lossi.
Okay, Basar PS case number 19/2023. Under section 417/420 IPC. Stop. By an order dated 26/9/2024, comma. This court, while calling for the record, has granted interim anticipatory bail to the accused petitioner with the direction that in the event of the accused applicant, namely Libom Boze, being arrested in connection with Basar PS case number 19/2023 under section 417/420 IPC, comma, he shall be released on interim bail on execution of bail bond of rupees 15,000 with 2 sureties of like amount, with a further condition that he shall cooperate and appear before the IO of the case within 7 days, within the period of 7 days. Stop. The Nara Council for the petitioner submits that in person to the said direction, comma, the accused, namely Libomboji, accused had appeared before the IO of the case at Basar on 29/9/2024. Stop. It is further submitted that on such appearance, comma, the accused Libomboji was arrested by the IO of the case in connection with the above Basar PS case number 19/2023. Stop. However, after completion of the formalities and recording, after completion of the formalities, including recording of police statement, comma, the accused was released on interim anticipatory bail on the strength of the bail order dated 26/9/2024, granted by this court. Stop. the Learned Counsel, the Learned Additional PD, Mr. Tata, produced the case diary and fairly submitted that as directed by this court, the accused had appeared before the eye of the case, and on his appearance, he was examined, interrogated, interrogated, and thereafter he was released on bail, on execution of a bail bond. With sureties. The surety as directed in the order dated 20, as per the direction of this court on 26/9/2024. Stop. In view of the above, and as the accused has already been arrested examined, and thereafter released on bail on execution of the bail bond with certain conditions, this bail application has become infructuous. Accordingly, the interim bail granted, interim anticipatory bail granted to the accused on 26/9/2024 is hereby made absolute, regularized and made absolute with the same terms and conditions, with the further condition that the accused shall appear before the eye of the case and the trial court as in one court. This bail order shall be read along with the bail order dated 26/9/2024. With the above, this bail application stands disposed of.
Obliged.
My please, my lord. This is re-arrest bail, my lord, in connection with the approach of case number 63, my lord. 63 of 24, my lord. On 26/9, my lord, interim protection was granted.
Yes, it appears same order.
Yes, my lord. And accordingly, I appeared on the next day, my lord, on 27/9.
Okay.
Otherwise, also, my lord, if your lordship would peruse the, my lord, FIR, my lord. On the face of it, it doesn't reveal anything.
Okay. So what is the allegation against it? The allegation against
I am just assuming, my lord, because there's some FIR is at, my lord, page 11, my lord. Type copy is at page 12.
Okay. Yes.
To the officer in charge so and so, FIR against so and so, the petitioner here in, my lord. Sir, I am directed to forward herewith copy of verification report is photography and other related papers of site where the government quarter number so and so was situated at so and so near so. The occupant and LOT of the said government quarter is so and so, so and so. Nothing, my lord. And otherwise, my lord, there is some proceeding going on under the Eviction Act, my lord.
Okay.
That we have already filed a writ petition WPC 433, my lord.
Okay.
And that order of the estate officer has already been stayed.
Hmm.
But otherwise, from the so I'm just assuming this is related to that, man. But on the face of it, this does not reveal anything, man. Any commission of any offense, man.
What is this? What is the offense registered?
3 PDPP, man.
Oh, section 3 PDP.
Yes, man.
Is the photography and other related papers site?
Doesn't say anything that I have destroyed this
Yes,
or
yes.
that.
No
Nothing.
allegation against it.
Nothing, man.
And what happened thereafter? You said
Lordship,
whether the record reveals that
he has appeared, Lordship, yes, Lordship, before the IO and give his statement.
I think similar order, I think.
Yes, my lord.
And interim anticipated bail also same.
Yes, it was, I think,
Okay,
in the same.
Okay, hard Ms. D. Sophie, counsel for the petition. I've also had Ms. El Hadi, Lana Edison PP for the state staff on para. This is an application under section 482 of the BNS. Praying for grant of pre-arrest bail, apprehending his arrest in connection with the Procedural PS case number 63/2024 under section 3 of the PDPP Act. Staff on para. By an order dated 26/9, same date. 26/9/2024, while calling for the case study, this court has extended the privilege of pre-arrest bail to the accused applicant Qasim Mosul. And directed that with the direction that in the event of the accused applicant being arrested in connection with the above the Procedural PS case number 63/2024 under section 3 of PDPP Act, he shall be released on interim bail on execution of a bail bond of rupees 10,000 only with 2 sureties of like amount with certain conditions. Stop. And with the and further directed that he shall appear before the eye of the case within 7 days from the said date, and from the date of the said order. Stop. Para. The Lana counsel for the petitioner submits that in compliance of the direction of this court, the accused Qasim Mosul, namely Qasim Mosul, had appeared before the eye of the case at the Procedural on 27/9/2024. It is further submitted as on his such appearance, the IO has examined and recorded his statement, and after completion of the procedure, completion of all procedure, the accused was released on interim anticipatory bail. On the strength of the bail order dated 26/9/2029. And executed the bail bond. Stop. On execution of a bail bond on the strength of the bail order dated 26/9/2024. Stop. The land counsel for a petitioner submits that otherwise also there is no allegation against the accused applicant for commission of any offense. Stop. Any offense, and pray for regularization of the interim anticipatory bail granted to the accused on 26/9/2024. Stop. Ms. El Hadi, Lana Edison PP, clearly submitted while submitting, while referring the case study and the status report, submitted that after obtaining the interim anticipatory bail, the petitioner has appeared before the eye of the case on 27/9/2024, and on his such appearance, the accused was arrested and subsequently released on interim anticipatory bail on the strength of the bail order anticipated bail order dated 26/9/2024. So in view of the above, and as submitted by in view of the above, it appears that the accused what is his name? What is his name?
Nothing more, sir.
Had been released on, already released on execution of a bail bond of rupees 10,000 with 2 sureties of like amount. Under the circumstances, sorry. It appears that that will be it. Starting it appears that in view of the above bail application has become infructuous. Accordingly, the interim anticipatory bail granted to the accused on 26/9/2024 is hereby regularized and made absolute with the same terms and conditions, with the further condition that the accused applicant shall cooperate with the IO and appear before the trial court as in when called for. With the, this bail application shall be read along with the bail order dated. So this bail order shall be read along with the bail order dated 26/9/2024. So, with the above, this bail application stands disposal. Yes. Yes.
Lordship, service to the respondents are completed.
Okay.
We'll file our affidavit.
Respondent number
1, 2, and 3, Lordship.
You are Mr.
S. Jiram.
Line counsel for the petitioner is present. The service report upon the respondent number. The service report upon the respondent number 1, 2, 3 are still awaited. In view of the above, list is matter after 3 weeks.
Lordship, the service is completed.
So now it's the report is still awaited.
Yes, we'll bring the record and we'll file our affidavit. We'll bring on the record and file our affidavit. It was taken through AD card.
Taken steps by way of trustee.
Not trustee, Lordship.
Then
register post and usual process.
Usual process, but
yes.
Service report is still awaited. It is
but
yet to receive.
Yes, they are
by the registry.
But register post it's already completed.
Where? But the report says as per the order.
Yes.
Order office note. What do you want?
We'll file our affidavit. Bringing
affidavit? What affidavit?
Bringing on record on that completion
that you
of
have taken steps.
Yes.
That is on record only. You have taken a step.
Yes.
You have
not
taken
not
a step.
Not steps, Lordship. We regarding completion of the regarding completion of the service.
Completion of service.
Yes.
Okay, then it has to be reported by the registry only. You tell the registrar.
Okay.
Tell the registry that since it is completed, and then write service completed. And the report also received on such and such date.
Okay.
Then we'll proceed. Okay. Okay. List is of 3 weeks. No? Okay. Yes.
Service report is still awaited. Service report is still awaited.
Awaited. Yes, same only. Same only. Okay, similar. Survey report is still awaited. This is what criminal petition.
Criminal petition, yes, Lordship.
Okay, still awaited. Service upon the respondent number 2 is still awaited.
Yes, Your Lordship. Here the respondent number 2 is the IS officer, Your Lordship. Now presently perhaps he's posting in some other place.
What is this case about? Washing petition?
On merit, Your Lordship. And there is an interim order, Your Lordship.
Okay.
They staying the proceeding against the present applicant, but against the other accused, the proceeding is going on. Yes, Your Lordship.
Okay, so that was not stayed.
That was not stayed. Only
state
in
of
yes,
the
yes, Your Lordship.
petitioner only.
Because here the petitioner is a professional and advocate, Your Lordship. A certain document has been provided to him by the client, which was alleged to have been, Your Lordship, leaked by some of the accused. regarding some interview there in Siang district, Your Lordship.
Okay.
So that allegation was there, and for that, Your Lordship, even this present applicant was aired as an accused. So considering the prima facie material, this court was pleased to stay the proceeding in respect of the present applicant, and issued notice was issued to the informant, who was the then DC of the Siang district, Your Lordship.
Okay. So then he was in the official capacity, but then of course he has to appear before the court.
Yes, Your Lordship.
So he cannot be represented by anyone if it was in the official capacity.
Your Lordship, the DC, the concerned DC who has registered or who filed the FIR,
Okay, so then he has.
he has to come, because Your Lordship, even if he is DC, but it simply says any person, he will be considered as a person only, Your Lordship, the
Right.
informant, whether he is DC or anyone.
So report is still awaited.
May await for the service report, or let them take a press steps, Your Lordship.
You want to take.
Lordship, we had just recently taken the steps. So
Recently only, October only.
Then in that case, Your Lordship, await for the service report.
Mr. Constable Division and Mr. Additional DP for the state staff. The service report upon the respondent material is still awaited. In view of the above, this is matter after 4 weeks.
4 weeks, yes, Your Lordship. Deeply obliged.
highly obliged.
Yeah.
Yes, Your Lordship. Your Lordship, on the last occasion, this court has directed executive magistrate to bring on record the LCR. And as per the case record, it's available, Your Lordship. So matter may be fixed for admission hearing, Your Lordship, since the report is already arrived.
Okay. Okay, hard, Mr.
Jade Singh, I'm for the respondent number 2, Your Lordship.
Okay, who is for the petition?
I'm for the state, Your Lordship.
Okay.
And the state is the respondent number 1.
Okay, Miss, hard, Miss?
R. Chungruja.
R.
Chungruja.
Jungluju, Land Council for the petitioner. I've also heard Mr. T. Lanet. State is one only?
Yes, Your Lordship.
Okay. Additional PP for the state respondent. And Mr.
Jade Singh for respondent
For
number 2.
respondent number 2.
Yes.
Okay, so the trial court record is called for has been received. This is matter
For admission hearing, Your Lordship.
for after 3 weeks. For admission here. Okay.
Obliged, Your
Item
number 20,
What?
Item number 20.
20, what you want?
order was there.
Interim order was there?
Yes.
What you want?
Let it may continue.
Okay, the item 20, huh? The interim order pass alias I continue till the next date. Okay.
Highly
Yes. No one appears on call. List is matter after 4 weeks. Okay. Just a minute, huh? Okay. No one appears on call, huh? So the petitioner is yet to take steps. So just a minute, in view of the office note dated 3/10/2024, the petitioner is directed to take steps upon the respondents within a week, within little vacation of it.
My lord, there is an interim prayer.
Okay, you are for the,
I'm for the petitioner. The interim,
where you were, when I recorded, no one appears.
no, 23, in the,
You have,
okay. Item number 423. This is item number. Was. My
you
lord,
are
I'm so
not
sorry,
on-
I'm,
Okay, you are in 23. Okay. Issuance of notice. Okay. It is the office note that 3/10/2024 reflect that the petitioner is yet to take steps upon the respondent. So the petitioner is directed to take steps upon the respondent. The vacation, then he is from outside. It will be difficult. Within 3 weeks, start. At least it's matter after 5 weeks. At least it's matter after 5 weeks. Yes.
my lord, in item number 23, there is an interim prayer.
Okay.
My interim prayer is that, my lord,
In the last time, the interim prayer was not granted. So I may be allowed to submit my prayer on interim. Your Honor, my lord, this is a, no, just a minute. Service is still awaited. Yes, my lord. What is this case about? My lord, this case is, fact of the case is that the Kurung Kume Enterprises firm was awarded a contract work. Thereafter, the proprietor of the Kurung Kume firm enterprises sublet this work to one Koda Raja, who is the petitioner herein. Thereafter, the petitioner carried out the work on behalf of the petitioner of the Kurung Kume Enterprises firm. And thereafter, petitioner was issued a running bill for the work carried out for the 2019 and 220. Then thereafter, 9 crore 63 lakhs running bill was issued. For the running bill, for this running bill, 9 crore 63 lakhs, 10% GST amount has to be paid to the GST department. Thereafter, the petitioner, my lord, requested the proprietor of the firm to open the GST account because his GST account was blocked by the department due to error backlog. Thereafter, my lord, the petitioner paid a sum of rupees 2,50,000 to clear the error block so that he could pay the GST amount of 10%. Even after payment of this 2,50,000 by the petitioner to clear the error block dues of the firms, he has not paid the GST. He has not paid to the department, and the GST account was closed. And thereafter, because the respondent, who is the Kurung Kume Enterprises. So let the other side here. My lord, there is an interim prayer is there because we have to make the because the trial court has already mentioned of 20%, and that too without without considering the load laid down by the Honorable Supreme Court. And in these two cases, two check was issued, my lord. My lord, kindly. There is no observation while passing order. Yes. At the time when he moved this back. And in so and before in two check were issued and one check High Court before High Court this Honorable High Court has stated in other, and because of the check was also deposited without the agreement. My lord, we come to page number 42. This is the terms and condition as to when the check should be deposited. And my lord, will kindly see this amount. My lord has got page number 42. The whole course of action arises out of this deed of understanding. Without fulfilling the terms and conditions of this agreement, Now my interim prayer is, my lord, to stay the operation of the impugned order dated 28/6/2024 till returnable date. In one of the checks, this honorable High Court already has stated.
One of the case.
Yes, because
have the
there
order?
also terms and condition of the agreement was not
Similar
fulfilled.
case.
Yes,
Where,
two check
do you
were
have the order?
issued.
Do you have the order?
Yes,
A copy of the order?
yes, yes. 63, page number 63. Page number 63. I have annexed in the case. My lord, in this case also, at the stage of motion, the stay was not granted, but at the stage of order, it was granted.
I have not, I think, satisfied the court then in the same case.
In the same case.
On the same day. It was on the same day probably.
This 1 crore 50 lakh, my lord, there is two check were issued. Page number 63, this honorable High Court stayed here.
This is stay the further proceeding of the
Yes.
complaint case.
Yes, yes.
But then here is the case where there is order. You are challenging the order.
My lord will come to page number 42. Then my lord will be very clear. In terms with this deed of agreement, the petitioner issued two check. Page number 40.
What is the agreement?
Agreement, clause 7 of the agreement in this.
What is this agreement about?
Agreement is about when to deposit this check.
What check?
This is a NI proceeding under 138 of the Negotiable Instrument Act.
Okay.
A check bounce case.
Okay.
And this was issued for a security purpose. And in the deed of the agreement, it was stipulated when to deposit it.
Where it is?
Page number 43.
7.
43, 7. That later on, if the voucher or case memo slip is produced by the first party and duly accepted by the tax department GST, the amount will be deducted accordingly from the GST amount to be paid by the first party to the second party. And because the GST account is blocked.
Just a minute. Huh? It was a case memo slip is produced by the first party. Who is first party?
First party is the petitioner.
Petitioner.
Yes.
And deed accepted by the tax department. The amount will be deducted accordingly from the GST amount to be paid by the first party, the second party.
And my lord,
whether the amount was paid, the case memo,
no,
voucher was.
Case memo or voucher is there because the GST account is closed. When the material are purchased, the GST is included. So that bill input has to be submitted by in the department in the website, GST website. But because the GST account is blocked
in the year 6/9/2022. Let us see the impugned order. What it says.
Page number 77.
This was agreement was executed.
Agreement was executed
way back in the year 22.
Yes.
So this impugned order was passed on 26/8/2024.
Yes.
After considering this case only.
No. Not
After considering
two separate complaint cases were filed before the JMFCT. And against the two cases, we have also filed a civil suit.
Let us forget the other case. Let us come to this court, this case. So in this case, although there is an agreement, after appreciation of all these only, after considering all these only, this impugned order was passed.
That is the reason why I have come before this honorable court. They have not appreciated without going into the merit of the case of the accused.
Let us see the impugned order then.
Fixed for hearing on. interim
Fixed for
compensation- Interim
the council.
compensation.
The council for the complaint is submit, the accused person has a financial capacity to make the check, 20% of the check amount as interim compensation.
Financial capacity to make
He has
payment of
submitted a
20%.
copy of the letter issued executive by IMC to show that accused person received a sum of 12 crore. As such, he pray for the interim compensation from the accused. On the other hand, the counsel of the accused person submit the check amount is 93 lakh is the amount payable by the accused person a GST payment. He has also submitted the accused person attempted to make the GST payment, but account of the GST account of the complainant being non-personal, the same could not be successfully done. He also submitted that currently there is no exact figure of GST payment to be made, as the GST amount of the complainant is not personal. He adds that while purchase of material and machinery, GST was paid by the accused person. It is the right that for granting interim compensation, the prima facie case has to be made out. Other thing, in the matter at hand, it is seen that complainant has made out a prima facie case in his favor. Among the, also from submission of the defense counsel, it is certain that accused person has financial capacity to make the payment. However, he has not raised objection in his so and so. He has raised objection stating that compliance of clause 7 of the deed of undertaking entered by the parties have not been satisfied. Considering the submission made and the fact that accused person has financial capacity, I deem it to direct the accused person to pay 20% of the check amount as interim compensation to the Rido Tavio, proprietor of the firms. However, this amount is payable to the GST. The petitioner is.
Now, you see, the 15, you were directed to make payment within 15 days.
Yes.
Now, how many days?
Now
has passed?
Thereafter, after realizing that it has to be paid within 60 days, the learned court below has extended up to 60 days, and
When?
60 days will
Where?
end in the 10th.
Where 60? It's 15 days only.
15 days. Thereafter, next date was on 9/9/2024. The petitioner appeared before the JMFC court and sought some more time. And he has.
Where is that granting of extension of time? Where is that order?
That order I have not annexed.
Now,
because we are challenging this order.
is to be stayed. Now, because subsequently, in continuation of this order, the period was extended.
Period was another 45 days was granted.
Where is that? Now, how this order can be stayed then? Because subsequently the order was passed.
No,
after this.
because the trial
In
was.
continuation of this order only.
When this writ petition was filed and when this was heard, the stay was not granted, so we could not stop the trial. Trial was not
You
stopped.
bring that also into record.
Yes, yes. In the next step, we'll definitely will bring.
Then only we will consider.
No, my lord, because why till returnable that stay may be granted, then because this Tuesday,
How
coming
we
Tuesday.
stay? Which one? Because subsequently, in continuation of this order, another order was passed on 9/9.
Not in continuation, my lord. Only time was extended. We have.
That is why I'm saying. That is why I'm saying time was extended for your convenience.
Because my lord,
you bring that also onto record,
The
and then
honor-
because we have to record, even if some order is to be passed.
the honorable
then
high.
This order, and I'm directing you to deposit within 15 days, and
Yes.
subsequently extended up to 45 days. That is to be recorded by order date so and so. It has to come on record. We
Yes.
can't.
Till returnable
Now you
date.
see, now on the record, it is said, it is that it cannot be stayed because the time already over. Time expired. The time given to you already expired. So had it been the case where no, it is yet to expire, then the stay is possible. But then you bring that order also on record.
It is fixed on
Subsequent order.
10. My lord, in that matter, in that case, it may be passed over for some time. We can have that paper also.
You have to file it, bring it on record by filing a small affidavit. It's additional affidavit. It has to come on record that way only.
My lord, basically, my challenge is, I'm
stay
challenging
because I think
because
the
this,
stay was initially not granted because on that day, there was a time, but then on that day, this having not been granted, it's very difficult.
my
Now,
lord, and one more
it stays.
aspect,
And then because subsequent development taking place, subsequently it was extended, and that is in continuation of this order only. Okay, as prayed for by.
my lord, and kindly have this case. This is the latest case where Supreme Court has said that when civil suit is pending, that no prayer of interim compensation should be granted. This is very clear. Paragraph 16.
What is pending?
Civil suit. In these two cases, civil suit is pending before the same court. For a declaration that this amount in the GST amount mentioned in the check is the GST amount payable to
You
the
said that
department.
this is check bounce case, but then this is, the direction is for the deposition of the.
My lord, because this, I am payable to
amount.
government. I am not legally, and I'm not legally, it is not legally enforceable debt what the.
Okay, you bring
respon-
that on record. We'll try.
My lord, if
So
the.
this is para?
if paragraph 16,
What it says?
paragraph 16, in the third class, there could be several other factors in the fact of the cases, such as pendency of the civil suit. While deciding the prayer made under 143A, this court must record. So when the civil suit is pending, that is also a ground for not granting the interim compensation. This is the latest case held in Rakesh Ranjan Srivastava case.
You should have shown it before the trial court.
My lord, we have on the same day, we have filed the written objection against the prayer of interim compensation. But without going into our petition, this order was mechanically passed. My lord will kindly see
Bring that on record, or otherwise it will have, this matter will be taken up only after.
My lord, by then this petition will be infractious, because by
You say
then
that the date has been extended, it was not infractious, that this was 4/9/2024, no stay was passed.
my lord, if the interim stay is not, I'm only praying for a stay till returnable date. It
That
may
is
be
what I am
fixed on
saying, till returnable,
2021.
we need to see the last
2021.
order. We need to see the last order.
Oh,
Because
in that case, my lord, it may be fixed, to be, last item, I'll bring that report. Okay, sir. Not so bad.
Yes. Yes.
My lordship, as per office note dated 3/10/2024, lordship, service against respondent is still abated.
Mr.
K. Lawrence.
Planning counsel for the petitioner, he is present. Staff service. Still, have you recorded the name?
K. Lawrence.
Planning counsel for the petitioner is present. Staff. The office note dated 3/10/2024 reflect that the service upon the respondent number,
Sole respondent, lordship.
sole respondent is still awaited. In view of the above, this matter after 3 weeks.
After 4 weeks.
4 weeks. Okay.
Of life. May I please, your lordship?
Yes.
Lordship, this is an application for certain amendment under paragraph 12 and 14 of civil revision petition 11 of 22. I've subbed a copy to the Respondent, Your Honor.
Okay, you have objection?
My lord, I have received the copy this morning only. So
Okay.
I have to go through the record.
Okay, Mr.
Ji, ji.
Sorry, Genie, Direct Counsel for the applicant. File this application. Mr. Genie, Direct Counsel for the applicant.
Ji, ji.
This is an application. J. Genie, Direct Counsel for the applicant. This is an application under file under section 151, read with order 6, rule 17 of Code of Civil Procedure 1908 for amendment of paragraph 12, 14, and the prayer portion of civil revision petition number 11 within bracket AP bracket close stroke 2023. Stop. Issue notice. Mr.
Modi.
Modi, sir. Modi, Direct Counsel.
Sole respondent.
Since Mr. Modi, Direct Counsel appear on behalf of the sole respondent and accepted notice, no formal notice need be issued. Stop. Mr. Modi, Father Praise for submits that accept notice on the of the sole respondent. No notice. How? Okay. Mr. Modi, Father submits that since he has received the application, a copy of the application filed by the petitioner, copy of the IA filed by the petitioner, he needs some time to go through the same and to file objection if required. Stop. So the prayer is allowed, list is matter after 3 weeks. Yes. Yes, what is this?
Lordship, this morning we mentioned this matter.
Okay. Mention for what? Adjournment?
Yes,
Okay, you are for?
respondent.
Respondent,
behalf of-
petitioner is not present.
Yes,
Okay, no one appears on behalf of the petitioner on call. Stop, Mr.
T. Darren.
While Mr. T.
T. Darren on behalf of the Pangal.
Okay, Direct Counsel appear on behalf of the respondent. Stop. In absence of the petitioner, the matter stands adjourned. In absence of the Direct Counsel for the petitioner, the matter stands adjourned. List is matter after 4 weeks. Okay.
Obliged.
Okay.
This bail application has been preferred under section 483 of the NSS for releasing the accused person Shri Samir Tamang, who has been arrested in connection with Badapung PS case number 9 of 2024 one. After a complaint was made by the victim, who has been arraigned as respondent number 2 hearing, she had alleged that the accused person had manipulated her.
What is the offense?
The FIR is at page number 17.
17, okay.
It has been registered under section 376 and section 4 of POCSO. 76.
217?
376 IPC, section 4 of POCSO. POCSO case.
When he was arrested?
He was arrested on 30th of August.
August.
Yes, ma'am.
Okay.
And there was an application, bail application that was applied before the Sessions Court, Bombila. However, the same was rejected.
Okay.
And then subsequently we've come before this honorable court.
Okay. When it was rejected? Last?
It is said that since the victim is a minor and it is in the initial stage, so there may be a chance of
When it
tampering.
was? It was rejected.
It
On
was
which date it
rejected
was-
on 19th of September 2024.
So what has changed status in the case?
There is no change as such, but then from the content of the FIR itself, Your Honor will see that the victim and the alleged accused person were in a relationship. And she
Victim
had
and?
stayed, the accused person, they were in a relationship. She had stayed as a wife with the alleged accused
Okay, but
person.
the victim, you said that he was a minor, he's a minor.
She was a minor, and even the accused person is of a very tender age. At the time, he was 19 years old, and the victim was around 15 to 16 years old when they were in a relationship. So thereafter, she had also gotten pregnant, and there were some abortions as well. My contention is that, Your Honor, because since the nature of the case is not of criminal intimidation or of forceful sexual assault, and it has, even in the FIR, it has only been mentioned that she has been manipulated by the accused person in marrying him. There is no like direct allegation as such that he has forced himself on her. So in view
Only
of that,
because she was a minor.
only because she was a minor, this case has been registered. But today, on a notice may be issued.
So how many days since then has passed?
Since he was arrested?
Yes. How many days
He
he
was
has been
arrested on
decided?
30th of August, so it
Okay.
will be a month
Okay.
and 5 days, 35, 36 days.
So nothing has changed if no any new ground. Is it proper to call the case there time and again for the same? Because on the same ground, your bail was rejected.
The charge sheet has not been filed yet.
No,
So
that
there
is what
may
I'm
have been
saying,
progress.
charge sheet not yet filed. During the
sir.
pendency of the investigation, during the investigation period only, you have filed, moved the bail application before the Planet Court, Special Court. The Special Court, after appreciating all those, that has rejected your bail. And since then, nothing has changed. No new ground has been taken. Then on the same ground, how do we appreciate and how do we grant bail? On the same ground. You say that there is no other ground. We also will be recording the same ground. It will
You
be
know,
automatically
not
rejected.
similar, not same ground, because there were a couple of other grounds that were taken before the
What
lower
has
court.
changed? What ground you have taken this time?
One of the main ground that I've stated, Your Honor, is this, that they were of a tender age, and this ground was not taken before the lower court.
That probably cannot be the reason at this stage, because it is still under investigation stage. How do we come into conclusion that?
But Your Honor,
Because
it has
it's
to
still
be,
under investigation only.
Yes, Your Honor,
Investigation
but
will
if
find
the-
whether there was a forceful or not.
the allegation in the FIR itself is not severe, Your Honor. And since the accused person is not a hardened criminal, if he is kept in the jail for a long time, along with the hardened criminals, his future is also in the risk of being impacted.
Is he minor? He's not a minor.
He's not minor, but he's around
Then-
20 or 21 years old. So in the interest of justice, Your Honor, because there are certain other cases also passed by the Honorable Bombay High Court.
So what to do, Mr. Tara?
Yes, here notice may be issued to the informant.
Call for the case diary?
Yes, CD may be called for.
Because CD was called for, and then during the investigation period only.
Yes, bail was rejected by the special court, not by this honorable court.
No, that is what I'm saying, but it's all the same.
Yes.
During the pendency of, during the investigation period, the fact or the materials will all be, or will be the same only. Okay, anyway, hard miss.
T.Y. Bhutia.
T.Y. Bhutia, learning counsel for the petitioner. This is an application under section 483 of the BNSS 2023, read with section 439 of the Code of Criminal Procedure 1973. Yes, within bracket now repeat, bracket close, stop here. Bracket close, comma, for praying for grant of bail to the accused Samir Tamang, who has been arrested in connection with Balupong PS case number 09/2024 under section 376 of the Indian Penal Code 1860. Read with section 4 of the Protection of Children from Sexual Offense Act 2012, staff. Call for the case diagram. Issue notice, since Mr. Tado additional PP, G Tado additional PP accepted notice on behalf of the state respondent. No formal notice need to be issued to the state respondent. Stop, however, the petitioner shall take steps upon the respondent number 2 by a registered post with, not registered post, through
jurisdictional PS.
through
Jurisdictional PS.
shall take steps upon the respondent number 2
CPS Balapong.
through the jurisdiction police
Station.
station. Through
To OCPS
yes,
Balapong.
okay, OCPS.
Yes.
OCPS Balapong. Okay. Balapong. List this matter when? After 3 weeks.
The explication.
After 3 weeks.
Yes.
Okay.
Obliged.
Lordship, yes, Mr. Tupu.
This is bail
What is
application.
this? Bail?
Yes, Lordship.
Yes, what is this? What is the allegation against? it?
Allegation is Lordship that sexual assault and to tend to load the video on the social media. On the basis,
376.
yes. So on the basis of that case is registered before the Women Police Station SEPA.
SEPA?
Yes, SEPA Women Police Station.
Okay.
And police has already completed the investigations and charged it before the POCSO court Bomdila.
Already charged.
Yes, even trial also already begun. Thereafter, principal, the man victim witness has already been recorded. Only doctor and IOS left.
So the evidence already, the victim has already been examined.
Yes, already examined.
Then why don't you file bail application?
I have filed bail application here, but learned POCSO court has rejected my bail application.
Okay, then rightly rejected must have been.
Because
Because he is the right
method of trial that is different. Lordship. A prosecution can be any allegations, but that will be seen in the trial. Lordship. So
No, why-
next is
There is nothing in the evidence according to
no, they have deposed, but Lordship, that is part of the prosecution. So next Lordship, it's
No,
my
what I'm saying is, what you have you annexed the evidence of the?
no evidence. I have not annexed, Lordship. I have annexed that's series of that
Then
recording
if
of
there is a material against the accused and the evidence also recorded, if evidence also has recorded, if there is a material and if there is evidence against accused, then how do you release?
Lordship, bail is a matter
It will
of,
be-
it's a bail is the matter of legal rights. So conviction is
Then
Teacher may call
Notice.
for
Hmm?
the screen copy of the
see again,
teacher.
you see, over and again, the victim is to be again notified, records to be called, and an unnecessary, probably if there, because if the trial court has recorded, means there is a material against you, incriminating material against you, in the evidence.
Lordship.
Anyway, okay, hard, Mr. T. Topper, planning counsel for the petitioner staff. This is an application filed under section 4A3 of the BNSS, BNSS 2023, praying for release of the accused, namely Roshan Talang, Roshan, R-O-S-H-A-N, Roshan Talang, T-A-L-A-N-G, on bail, who has been arrested in connection with the Bomdila POCSO case number 08-2024, arising out of SEPA WPS case number 10/2024 under section 376 within bracket 2 within bracket F within bracket I J N stroke 376 within bracket 3 bracket close IPC read with section 6 of POCSO Act. Start. Issue notice returnable by 3 weeks. Call for the scanned copy of the trial court record. Since Mr. Miss L. Hagen, Planet Additional PP has accepted notice on behalf of the state respondent. No,
Yeah, there was a POCSO matter, Lordship. A victim
Yes, no.
may be, victim party may be, Lordship.
where is it? Where is the victim?
Lordship, in this case, victim is already, their role has already been done.
No, but then she's agreed.
We'll file additional lordship in meanwhile.
No, you have to file first. Even to know,
Yes, exactly.
yeah, you have to file first in
There
order
is
to issue
Supreme Court
notice.
judgment.
Whom do we issue notice now without name?
All right, lordship.
You have to file first.
Right, implement.
You're supposed to know this by now. In the POCSO case, it's compulsory. There is a direction. You first have to implement.
We'll change the course title.
You have to change. See, tomorrow vacation, and on the last day you're getting, why
Okay,
you did not file yesterday? You could have filed yesterday, could have corrected. Can you make it now?
We'll do it.
Huh?
We'll do it after, within 15 minutes we'll do it.
Within 15 minutes. How you'll do?
We have some copy.
Tomorrow, the vacation starts tomorrow. And then you are filing today with this. Okay, after some time, huh? If he can manage, let us see. Now it's.
May I please, my lord? My lord, this is a joint criminal petition under section 528 of BNSS. My lord, there, in this case, an FIR has been filed against me, not against me,
Okay.
on dated 15/09/2024. FIR is at page number 14, Your Worship.
What is the offense? What is the
Offense?
allegation against?
Allegation is under 62, section 62,
76.
76, 331.
What is 62?
62 is, may I read, Your Worship?
Yes.
62. To punishment for attempting to commit offences punishable with imprisonment for life or other imprisonment. Whoever attempts to commit an offence punishable by this Sanhita with imprisonment for life or imprisonment, or to cause such an offence to be committed, and if such attempt does any act towards the commission of the offence shall, where no express provision is made by the Sanhita for the punishment of such attempt, be punished with imprisonment of any description provided for the offence, for the term which may extend to 1/2 of the imprisonment of life.
What is 76?
26.
Assault or use of criminal force to women with intent to disrobe.
It is the corresponding to the IPC is 62.
62 cross, Your Lordship, the corresponding sections are
354.
354B.
354.
B of 76
is
corresponding to 354B of the IPC.
okay, and then 331.
331, Your Lordship,
331 2 4 354.
Punishment of
331 2. Punishment for house trespass or house breaking.
Okay, 31 4 is 331 4 is
331 4 is, Your Lordship, whosoever commit lurking house trespass or housing breaking after sunset and before sunrise.
351 3.
351 3.
Intimidation.
Criminal intimidation.
506. Okay. Just
Corresponding section 506.
Your Lordship, may I please, Your Lordship?
Yeah.
Your Lordship, this FIR has been filed due to misunderstanding and misconception. Your Lordship.
How?
Yeah, the facts. May I read the FIR?
Yes.
The allegation made in this FIR is, I would like to inform you that I am a housewife living with my husband in Dari town. My husband is a teacher at the government school in Dari and we reside in a government quarter. On the night of 14th September at approximately 12:25 to 12:45 a.m., while we were sleeping in our bedroom, I felt someone pulling the blanket. Instantly, I woke up and saw Sri Hengobam near my
Hengobam is the accused?
Yes, Your Lordship.
Hmm.
Hengobam near my face, attempting to kiss me. When he noticed my eyes were open, he gestured for me not to shout by placing his finger on his lips. However, I screamed loudly, causing him to flee. My husband tried to catch him, but he managed to escape. Upon checking the house, we discovered that all the lights had been turned off by him, except for the common room light adjacent to our bedroom. We also found that the back door of our house had been broken with an iron rod. Additionally, we noticed a bike parked in front of our gate, which my husband recognized as belonging to the intruder. He had abandoned.
Okay, so what happened thereafter?
There-
Mutual settlement?
Yes, Your Lordship, there is a
You can issue notice or what?
Yes, Your Lordship, issue notice at this moment, the investigation is still progressing. So investigation may not be stalled, Your Lordship, at this moment because
Ultimately, it might go.
yes, but yes, Your Lordship, if suppose if investigation
But-
is stayed.
No, that will not stay now.
Yes, yes, Your Lordship.
Ultimately, it may go, but then will not stay for
Yes,
the
yes.
investigation. Investigation, we cannot interfere with.
Yes, Your Lordship.
Okay.
Then
Mr.
notice issue.
M. Ratan, Your Lordship.
Planning Council for that. Have you recorded? Name?
M. Ratan.
Yes. Planning Council for the petition.
Ratan, R-A-T.
Ratan. So for the Arunachali, difficult to write the name of those states, and for them it's difficult. That's why. Okay. This is an application filed under section 528 of the BNS 2023. Praying for quashing of FIR.
FIR, Lordship.
Passing away file, Your Lordship.
Dated 15/9/2024. Which was registered as Basar PS case number 22/2024 under section 62/76/331 within bracket 2 bracket close stroke 331/4 351/3 of BNS 2023. Stop. Call for the scanned copy of
Case diary.
the case diary. Issue notice. Since Mr. T. Planet additional DP accepted notice on behalf of the state respondent, no formal notice may be issued. Start. List this matter after 3 weeks.
3 weeks. Yes, Lordship.
Okay.
Oblige, Your Lordship.
Yeah.
This is also a joint application okay, for washing of charge sheet.
Okay. Washing off?
Charge sheet pending before CGM Pasigar.
Okay.
Offense is 387 Lordship, extortion.
387.
Lordship. Punishment
BNS?
up to 7 years.
387 of IPC or BNS?
IPC Lordship.
IPC.
All case.
What is
This
that?
case is of 2011 Lordship.
2011.
Lordship.
What is 386?
387 is extortion.
Oh, 287.
387.
Oh, 387.
Lordship, extortion.
Okay, okay.
Lordship,
2011.
Lordship, this
What is the punishment?
up to
7
7
years.
years.
Up to 7 years. Is there any minimum?
Minimum? Lordship,
No minimum.
No minimum.
Okay. We can call for the scanned copy of the record.
Yes.
Whether the trial
Begun, Lordship, already begun and
evidence recorded already?
and not yet, Lordship.
Not yet.
Four-
2011 case, not yet.
Not yet.
Oh.
4/11 November, 4 November is fixed for PWC.
November, PW.
Lordship.
Okay.
Page 18, Lordship, annexure 2, I have annexed that order.
Already recorded the evidence of the informant.
No, Lordship, charges has been framed. Lordship.
Oh, only charges framed.
Charge has been
Okay,
framed.
not even a single witness has been
Examined.
Okay.
Oh, that fixed, next date is fixed on 4th November.
Okay, Mr. J. Jimmy, Land Council for the petition of stop. This is an application under section 482 of the Criminal Procedure Code 1973. Within bracket correspondent section 528 of BNS, 2023, bracket close, stop. For, bracket close, for passing of the, where is GR case, have you mentioned?
Year in the next page, Lordship,
Okay.
page 2. GR case
Of
number
the GR
19 of
case
11.
number 19 stroke 19 stroke 11 arising out of the Ruxin police station case or number, where is it?
Same number, FIR number 19 of 11.
Okay, 1911
Dated 10/12/2020, 2011.
arising out of FIR number, arising out of okay, Ruxin police station case number 1911 pending before the Court of Chief Judicial Magistrate, Pasigat. Stop. Call for the scanned copy of the trial court record. Issue notice. Stop. Since Mr. Tado, G. Tado, landed additional PP, has accepted notice on behalf of the state respondent to come. No formal notice need to be issued to the state respondent. Stop. Where is the informant?
This is a joint petition.
Joint petition?
Yes, Lord.
No, petitioner number 1 only. Okay.
Two,
Yes,
two is
right,
okay.
right. Then this is a joint petition filed by the petitioners. And it will be S. No? Yes. Okay. So having heard, it is having heard, sorry, just a minute. Upon consideration of the contention made and after hearing the parties come in the interim, it is provided that the further proceeding of the GR case number 1911 pending before the Court of the Chief Judicial Magistrate Pasigat shall remain state till the next returnable date. Start. Please this matter after 4 weeks.
Obliged.
Yes.
My lord, in item number 23.
Item 23. Yes.
Just now we have received the order.
Okay.
Certified to copy.
Now you have to file it in the additional
Yes,
affidavit.
my lord, by next date I will file because the deponent has to come for signing the affidavit. My lord, with regard to date, I have made a wrong submit. I seek apology because in my diary, the date was noted 10/10/2024, but after seeing this order, this is fixed on 24/10/2024.
report and payment. My respectful submission would be till returnable date that interim stay may be granted in the order dated 26/8/2024, whereby the petitioner was directed to pay the interim compensation of 20% of the check amount. Where is the interim order? Last page 77. Pardon, Mr. T. Sunil. Sunil. Not counsel for the petitioner. This is an application filed under section 438, read with 442 of the BNSS, Bharatiya, right, for Bharatiya Nagrik Suraksha Sanita, 2023. Challenging the impugn order dated 26/8/2024. This probably was on your prayer this extended. Yes, my lord. Because as per the law, 60 days time shall be given to the accused to pay the interim compensation. However, initially, the learner JMFC below has given 15 days. So, but then the trial proceeding is going on. Yes, that cannot be stayed. That cannot be stayed. Okay, my lord. Just a minute. By filing this application, the petitioner has assailed the order dated 26/8/2024, passed by the learned Judicial Magistrate First Class Capital Complex UPR in complaint case number 121/2023, whereby the learned magistrate in the interim, whereby the learned magistrate directed the petitioner whereby the learned magistrate, while granting interim payment, has directed the petitioner to make 20% of the check amount as the interim compensation. Within 15 days of the said order. So the petitioner has also challenged the subsequent order dated 9/9. You have to file additional. Yes. The petitioner also placed the order dated 9/9/2024, stating that by the said order, the additional said order additional time for 45 days was granted to the petitioner to make 20% of the to make 20% of the check amount as the interim compensation. Start issue. After this, no one appears on behalf of the sole respondent. Okay. Then later on, the record, the office note dated 3/10/2024 reflects that the service upon the respondent, the sole respondent is still awaited. Para. In view of the above, list is matter after 3 weeks. Start. Para. Having regards to the contention made in the petition and contention made and the submission of the Ghana Council for the petition of common, it is provided that if returnable, it is provided that the operation of the order dated 26/8/2024 with regards to the direction to the accused, direction to the petitioner to make 20% of the check amount. With regards to the direction to the petitioner to make 20% of the check amount, they said deposit. Where it is said? 20% to be deposited where?
In the last page.
Accused person to make 20% of the check amount as the interim compensation to whom?
To the petitioner, to the complainant.
Okay. Okay. With regards to the direction. That the accused petitioner to make 20% of the check amount as the interim compensation. Within 15 days from the date of said order and extended for another 45 days by order dated 9/9/2024 till the returnable date, till the returnable date. Okay. Least is matter after 3 weeks. Much surprise. What is that?
Lordship,
okay.
Yes, I will just make it correct after some time, but that may be implemented as a party victim. Just everything I have done, just.
Okay, record, we have already recorded, I think 38. Was it you or somebody else? Okay. Mr. Peter Po. What was to be called for the case diary or what?
TCR, Lordship, scan copy of the TCR.
Okay.
Record.
TCR, we have recorded. Okay, you should notice. Yeah? Okay, since Miss that is also there. Okay, list this matter. After?
On 22.
No, okay. Issue notice, Miss accept the notice on behalf of the state respondent, okay? The petitioner shall take steps upon, sorry, the notice upon the respondent number 2 shall be served through the jurisdiction of OCPS, which
OC or PS SEPA.
okay, through the OCPS women PS. The step is to be taken by them only, initiated by them only, the petitioner.
Lordship, through our PP office, we can also do lordship.
Okay, through PP.
Through PP office, lordship.
Through PP office, huh?
It will go to the registry to the PP lordship.
Okay.
First it
Then
goes to-
how it will be recorded?
Through the PP office, lordship.
Not through the, okay. The.
Lordship,
notice upon-
on the first lordship, today is the motion state lordship, let the petitioner party lordship, they will take notice lordship, serve the notice. If on the next date, we'll serve
the
lordship.
notice upon the respondent shall be affected. The respondent number 2 shall be affected by the petitioner.
Petitioner, this time petitioner lordship.
Okay, through the
By-
office of PP.
No, lordship, this time the petitioner only lordship. On the next occasion, if notice not served,
Okay,
then we'll
through
go for it.
the women PS SEPA. The step be taken within 7 days from today. So at least this matter after.
Lordship, fix on 22 October.
No.
After petition 22.
No, 22 immediately probably it will not be because office also will.
Please after puja vacation.
Puja vacation 22 only. So it will be say let us fix 29. Okay, least this matter.
TCR lordship, it may take some time. Lordship.
29 it will take.
But holiday will be only, I think,
Okay.
1 week only.
Okay. Yes. Okay.